8:06. The parties and counsel are present. Next witness for the defense.
Your Honor, the defense would call Robin McKinley.
Solemnly swear or affirm that the testimony that you're about to give will be the truth and nothing but the truth. All right. I'm going to ask that you speak a little bit loudly or close to the microphone due to the glass panels. And if you could, please state your first and last name and spell your last name for the court reporter.
My name is Robin McKinley, McKinley.
Your witness.
Thank you, Your Honor. Good morning, Ms. McKinley.
Morning.
Could I have you start by introducing yourself to the jury, if you would, and tell us how you're currently employed?
My name is Robin McKinley. I'm currently employed with the Memphis Fire Department, and I'm also employed with a small community college in the city of Memphis.
And can you tell us what you do for the Memphis Fire Department?
Well, currently I'm a EMS lieutenant, but at the time I was retained for this case, I was a firefighter paramedic.
How long, can you tell us your background, your educational and your background that made you a paramedic, led you to being a paramedic?
Well, I started out, I went to Memphis State University, which is now University of Memphis. I took my EMT there. And afterwards, I went to work for a few private ambulance services. Back then, you had to have so many years of experience to become a paramedic. So once I got that experience, I went to the community college, which for now I work, and got my paramedic license. And I was hired on to the Memphis Fire Department.
And when did you get your paramedic license?
I finished paramedic school late 1998, and because of the holiday, I didn't receive the license until early January of the next year.
Right. And since that time, have you been working full-time as a paramedic?
That's correct.
Was that all for the city of Memphis with the fire department?
No, sir. I worked for a few private ambulance companies in Memphis. Should I name them?
Sure.
I worked for a company called Medic Ambulance. It was a 911 service and city service for the city of Memphis. We ran county 911, and we did the basic, as we call it, renal roundup for the city, doctor's appointments, doctor's offices, rollover calls, things like that. I also worked for a service called ASI Ambulance Service, who was the next company that got the county contract service. And I worked for them until they went out of business. Then I worked for another ambulance service, Impact Ambulance Service.
And that's all over about the last 25 years or so, is that right?
That's correct.
Okay. As a paramedic, are you required to follow protocols?
Yes.
And are those basically the standards of care for a paramedic, the local protocols?
Yes.
You indicated you were contacted with respect to the Elijah McClain case, is that right?
Correct.
And specifically, were you asked to focus on the Elijah McClain case after fire arrived on the scene with Elijah McClain?
That's correct.
And did you in fact undertake a review of a number of materials in connection with your review of the Elijah McClain case?
That's correct.
Can you give us a little summary of what you've reviewed in connection with your review of the case?
I reviewed, of course, the body cam footage of when the paramedics first arrived on scene. I reviewed their patient care reports. I reviewed their protocols. I reviewed their ketamine training.
Okay. Did you also review transcripts of interviews with various people who were at the scene?
I did.
Did that include police officers as well as Fire Medic Cooper and Lieutenant Cichuniec?
Yes.
When you indicated you reviewed protocols, were those the Aurora, Colorado protocols that were in effect in August of 2019?
Yes.
Your Honor, at this time, I'm going to move to qualify Ms. McKinley as an expert in the practice of paramedic medicine. Announce that she be allowed to give opinions in that area.
Or Dyer, or objection.
Ms. McKinley, did you just mention that the standards that you're following are the national standards, which are the same as the local standards?
Did I just mention that?
Yeah, was that what you were just talking about?
No, sir.
Where do the standards for the general parts of paramedic practice in Aurora Fire Rescue, like how to do a patient assessment and stuff like that, come from?
Okay, I'm not understanding what you're asking me.
Yeah, sorry. Where does the information you're relying on for the standards that AFR paramedics use for basic paramedic skills, like assessing a patient, where does that come from?
From the medical director.
So are you saying that the medical director in Aurora has a specific protocol about how to assess a patient?
He makes those, authors those protocols, yes.
Okay, which protocol is it that he has authored that indicates how you're supposed to assess a patient?
He authors the protocols in which they use, correct?
Is it fair to say you don't know which protocol it is where he describes how to assess a patient?
Okay, I may be confused about what you're asking me, sir.
So when you offer opinions about the performance of the Aurora Fire paramedics on basic stuff like patient assessment, I'm trying to understand how you're evaluating that. Is that based against some sort of national standard, or it sounds like it's based upon a local protocol?
It's based upon their training in paramedic school and their local protocols for which they work.
Did you review a copy of the paramedic school curriculum for these defendants?
I did not.
Do any training materials from these defendants related to how to assess a patient?
Other than their protocols, no.
And you can't tell me which protocol it is that discusses how to assess a patient?
But are you speaking of the actual protocol, like the general
Yes, ma'am.
patient protocol or general assessment?
Yes, ma'am.
Okay.
And you're not familiar with any one specific in the Aurora Fire system that would cover that?
I'm not understanding. Are you asking who wrote the protocols? Or are you asking, I'm not sure what you're asking.
Sure. I'm asking where the information is located on how they are supposed to assess a patient.
Okay, in their protocols.
Okay. And now I'm asking which protocol?
It depends on, I guess, the call that they're making. Are you just saying the general
Yes.
patient assessment? I can't give you the exact page.
Fair to say there isn't such a protocol, right?
I mean, for a general assessment,
Right.
there is a general assessment, but I don't know if you would call it general in those words. But I'm sure there's a patient assessment. I do remember reading one.
Okay. Do you know what number it is, where it's located, that you remember reading?
I do not.
Now, in terms of your experience, you mentioned you worked at the Memphis Fire Department for 10 years, or for a lot longer than 10 years. How long?
Almost 23 years now.
Okay. Did you work with Mr. Ludwig there?
Yes, I worked with him in the early 2000s.
Okay. Did you guys work together for about a decade?
Well, we didn't work together. He was much higher ranked.
Okay. He was your boss?
He was not my direct boss, no.
Okay. He was just a much higher ranked medic
Yeah,
than
he
you?
was command staff, so I had no association with him.
Now, with regards to your opinions in this case, has Mr. Ludwig served as sort of a mentor for you as you provide expert opinions in cases?
I'm not understanding what you're asking.
Well, for example, he's provided you with some of his prior reports so that you could copy some of the language from them.
No.
in particular, the standards section of your report, where you describe where the national standards for paramedic training come from, is identical to parts of the section from his report, right?
I would have to see it.
Would you please show to the witness her report and Mr. Ludwig's report? I believe page 9 from Mr. Ludwig's and page 5.
Judge, I'm going to object. This is certainly ample area for cross. I don't think that this is what you're doing.
Judge, I think this goes to whether these are her opinions or just repetitive of Mr. Ludwig's.
That's fine. We discussed that at the bench. The court will deal with those objections as they come. The court sustains the objection.
In terms of your testimony here today and the opinions you're going to offer, have you spoken to Mr. Ludwig in the last week or corresponded with him at all?
No,
Have you had any contact with him over the last year?
no,
Okay. Have you had any contact with him at all related to anything related to this case?
no.
That's all the voir dire questions I have for you right now.
Yeah.
The characterization, especially as to any general paramedic practice, as she, for example, with regards to the assessment, indicated that her opinions were based on a protocol that she doesn't know what it is. So the court does not exist, that there is no general patient assessment protocol for the
Response.
Judge, she testified that she relied on the training that paramedics have received as well as the protocols and is familiar through her own training experience with the training as well. But specifically regarding testimony about Aurora, she testified it's both the training and the protocols.
Well, I'll allow the witness to testify and offer opinions in the areas of the training and the protocols based upon the materials she's reviewed, but not patient assessment without further foundation.
Ms. McKinley, you indicated you reviewed body-worn camera footage. Is that correct?
Right.
And regarding the body-worn camera footage, did you review as well a video of the Shell gas station where Elijah McClain was previously?
I did.
Did you review police officers' body cams leading up to fire arriving on the scene?
Yes, I did.
I asked you when I was qualifying you as an expert whether you specifically focused on after fire arrived at the scene. Is that what you specifically focused on?
Yes,
But you reviewed other body camera footage as well, is that right?
yes.
Now, in making an evaluation or informing an opinion of what the fire department did while on scene, did you initially look at when they first arrived and what contact they had or didn't have with Elijah McClain?
Yes.
And can you briefly describe that contact or lack thereof with Elijah McClain?
Yes, I saw that they came over. I saw a young man put down what looks like an orange Pelican case. And I saw another young man come over and engage with the officers while the other personnel just kind of encircled the area where Mr. McClain was. I was just kind of surveying the scene.
You indicated that one young man brought an orange case, is that correct?
Yes,
Is it your experience that there are other cases that paramedics carry as well?
they can.
And did you later read transcripts of interviews regarding the orange case?
I can't say specifically regarding the orange case.
Okay.
But I did see somewhere where they bought a kit.
Specifically with respect to fire medic Cooper, did you observe where he was in relation to Elijah McClain?
Yes.
Objection to just narration of facts that are already.
All right, the court will, well, response.
Judge, this is foundational for a series of questions regarding what she observed and her opinions on that.
All right, the court will, as it's been represented as foundational, overrule the objection.
And I asked you whether you saw where Fire Medic Cooper was in relation to Elijah McClain on the ground.
Yes.
And where was that?
He looked to be on the right back of him, I guess if I'm saying that right.
Okay.
I'm looking at the video, so it appears he's on his, kind of on his left side a little bit, so I would say he was behind
Okay.
Elijah.
And you were speaking about when he first arrives?
Yes.
I asked you, I want to back up for a second. I asked you about the orange kit. In reviewing the Aurora protocols in effect in 2019, was there any specific protocol about bringing equipment to a patient?
I did not see one.
Was there anything about bringing the orange kit or any other kit directly to the patient's side in the protocols that you reviewed?
Objection, just asked and answered.
It was a different question, I'll allow it.
Can you repeat it? I'm
Sure. Was there anything regarding bringing the orange kit or any other kit of equipment to the side of a patient in the protocols that you reviewed?
I didn't see one.
Is there a protocol that you reviewed? You testified about assessments. Is there a protocol that you reviewed that says a paramedic has to go hands-on to do an assessment?
No.
In your experience, can you do an assessment without putting hands on a patient?
Objection of relevance beyond the scope.
Sustain.
Are you familiar with a condition called excited delirium?
I am.
And what is your understanding of the condition of excited delirium?
Excited delirium is a condition where
To phrasing and relevance, it doesn't go to. Object to relevance as it would go to her understanding rather than the Aurora Fire protocols.
I can rephrase the question, Your Honor. It was foundational, but I can rephrase.
All right, why don't you rephrase?
Did you review specific Aurora 2019 protocols dealing with excited delirium?
I did.
Are you yourself familiar with that term that's used in the protocol, excited delirium?
I am.
And the term that's used in the protocol, excited delirium, what is your understanding of that condition?
My understanding of excited delirium is it's a condition to where a person they can be over agitated, they can be over aggressive, they can show great strength, they can be disoriented, they can not follow commands, they cannot feel pain.
The condition described as excited delirium in the protocol, do you have experience with that yourself, dealing with patients with that?
I do.
You indicated some of the signs. Is that a fair word to use for excited delirium? Some of the signs you look for?
Okay.
Or is it fair to say symptoms?
Signs and symptoms.
And does the protocol instruct paramedics on some specific signs they can look for?
Yes,
Did you review their training with respect to excited delirium as well?
I did.
And does the training indicate other signs a paramedic should be looking for excited delirium?
Yes.
Does the
If I could just ask the witness to get a little closer to the microphone, please.
Yes, sir.
Go ahead, sorry.
Sure. Yes, sir. Ms. McKinley, does the The microphone moves too, if you need to move it. All right. All right. Ms. McKinley, the Aurora protocols, do they specify that all of a set of symptoms or signs must be found for excited delirium, or what do they instruct the paramedics in that regard?
It doesn't state all must be present.
Given the protocol that was in effect in Aurora in 2019, if a paramedic believes he or she is seeing signs of excited delirium, what are they required to do?
To try to intercede and stop that process.
And how are they instructed in the protocol to stop that process? Is there something supposed to give?
They're instructed to give ketamine.
And the protocols that you reviewed, including the specific one related to excited delirium, does it specifically say ketamine is what is to be given?
Objection leading.
Sustained, rephrase.
If the paramedic makes a determination of excited delirium, is there any other medication provided in that protocol?
No.
From your observation, I take it you watched and you listened to the body-worn cameras, is that right?
Correct.
That footage?
Correct.
And given your watching the body cam footage, given your listening to it, your review of all the other materials that you reviewed, did you form an opinion to a reasonable degree of professional certainty regarding Fire Medic Cooper not bending down and putting his hands on Elijah McClain?
Objection cumulative, not relevant to the expertise endorsed, as the jury can just see for themselves what's happening.
I'm asking specifically for an opinion on that, not what happened.
All right. Well, I'll allow you to rephrase with relation to the protocols.
Specifically with relation to the protocols and the standard of care that's established in the Aurora protocols, okay? That's specifically what I'm asking you about, okay, Ms. McKinley? Did you form an opinion whether Mr. Cooper's failure to kneel down and put his hands on Elijah McClain was a violation of those protocols?
Objection goes to assessment, which he's not qualified to analyze, and also cumulative of Mr. Ludwig's testimony.
Response.
Judge, this is not cumulative to Mr. Ludwig's testimony. He was never specifically asked this question. It is certainly relevant to her opinion as an expert, as she's been qualified in. She's been qualified in paramedic care generally and specifically with the Aurora protocols, and I'm asking her whether that would be a violation of the Aurora protocols.
All right. I'll allow the witness to answer.
Can you repeat it for me?
Repeat?
Yes, sir.
Sure.
Thank you.
Keeping in mind the standard of care as set forth in the Aurora protocols of 2019. What you saw and heard on the body cam and all of the evidence you reviewed, did you form an opinion whether Mr. Cooper's failure to kneel down at Elijah McClain's side and place his hands on him violated the protocols he was operating under?
Objection foundation. There's no protocol that deals with kneeling down, and he's asking about assessment, which she's already been not qualified to talk about. So there's no foundation.
Response.
Judge, the prosecution has made an issue out of the failure to kneel down and put his hands on the patient. I'm going over with an expert in paramedic care and the protocols, whether in her opinion, that behavior or lack of behavior would be a violation of the protocols.
Then the foundation would be that there's a protocol that bears on this. I don't believe there is.
All right. Yeah, if there's no protocol on it, I don't know how it would opine on the local standards. So I'll sustain the objection.
In your review of the excited delirium protocol, Ms. McKinley, and you testified that it says to give ketamine, is that right?
Correct.
There are other boxes besides just give ketamine on that protocol. Is that correct?
Correct.
Do any of them instruct a paramedic specifically on kneeling beside the patient or putting hands on patient before administering ketamine?
No.
Did you review any protocol that deals with how a paramedic is to assess the weight of a patient?
From the Aurora protocols?
Correct.
No.
Are you aware of training that paramedics received related to the weight of a patient, assessing the weight of a patient?
Yes.
Did you review both PowerPoint as well as a transcript of Travis Chambers' interview with the detective?
Yes.
And in reviewing that information, did you form an opinion about how paramedics were told to weigh patients or what instruction they were given in that regard?
Yes.
And what was that?
They were given kind of like a general scale of a 300 milligram, 400 milligram, 500 milligram, which the 300 is for the small patient, the 400 is for the medium-sized patient, and the 500 is for the large patient.
Did you see anything in the protocols that instructed paramedics they should have a discussion with other people about the weight of a patient,
No.
whether fellow paramedics or police officers?
No.
Outside of the training that kind of encompassed 300, 400, 500 that you just testified to, were there any specifics in either the protocols or the training that you reviewed regarding how to assess a patient's weight?
No.
Based on your observation, specifically of the body-worn cameras, did you observe anything that would have made it difficult to assess Elijah McClain's weight?
I observed that he had several officers on top of him. I observed that he had outerwear on, and it was somewhat dark in that area.
From what you observed regarding the body-worn cameras and what you review, all the things you reviewed, did you form an opinion about whether Mr. McClain was showing any signs of excited delirium?
Okay, repeat that for me. I'm sorry.
Yes. Based on all of your review, body-worn cameras and everything else, did you form an opinion whether Elijah McClain was showing any signs or symptoms of excited delirium?
Yes.
And what was your opinion in that regard?
My opinion is that Mr. McClain, he seemed very strong. He had several officers on top of him. He was steadily aggressive. He kept moving around, even though they were giving commands. He continued to fight even though they were on pressure points. So that would lead me to believe that he was suffering from excited delirium.
And you were focused specifically on after fire arrived at the scene, is that right?
Correct.
Ms. McKinley, did you observe as well Mr. McClain actually being administered the ketamine and what happened after that?
I did.
Do you have an opinion? Did you form an opinion based on your review about the decision to wait a minute or two for the ketamine to take effect before doing anything else with Mr. McClain?
Yes.
And what was that opinion?
You have to make sure that the patient is actually sedated. I mean, sometimes they lay there and take what I call, a power nap or a downtime. And then sometimes they can spring back up without warning.
And does the protocol on excited delirium and what you do afterwards specifically say once sedated, other steps should be taken?
I'm not understanding what you're asking.
In the protocol, does it specifically say that paramedics should wait until the patient is once sedated before taking other actions?
Objection leading and also cumulatively, Mr. Ludwig.
Overruled.
What I understood from the protocol is once the patient is sedated, then you restrain them and then you start your assessment of them.
And that's specifically what the agitated patient protocol says. Is that right?
Objection leading.
Sustain.
Is that what the agitated protocol calls for?
Objection still leading, especially in context of the prior question.
The second question isn't leading, Your Honor.
All right, let's try to refrain from leading questions, please, but the witness can answer.
Yes.
Following the administration of ketamine, were you able to hear Fire Medic Cooper saying things, outlining basically a plan?
I did.
And what was the nature of that plan he was outlining?
He was outlining what would happen once Mr. McClain was stabilized and sedated.
And what specifically was he outlining?
He was outlining what he would do, get him onto the stretcher, secure him in the soft restraints, and then get him loaded into the unit to get the suction, to get to tidal CO2, and to just get the assessment moving.
Was it where did you understand from your review of this that suction equipment and capnography equipment was?
It was in the ambulance.
And where did you understand Mr. Cooper was expressing he would take Mr. McClain to do those assessments?
To the ambulance.
In your opinion, was the decision to move Mr. McClain to the ambulance before undertaking that procedure with that equipment, was that outside of the protocol?
No.
In your opinion, was that following the protocol?
Yes.
Why?
Because the actions were still done. That's what the protocol dictates.
In reviewing the protocol, did you see anywhere in the protocol an instruction, and I'm specifically talking about the agitated patient that deals with excited delirium, okay?
Okay.
Did you see anywhere in that protocol that post-administration equipment should be brought to the patient's side?
No.
How does the protocol deal with what a paramedic should do after administering ketamine?
I'm not understanding the question.
Does the protocol lay out specifically where that equipment should be hooked up?
No.
Does it say when that equipment should be hooked up?
No. I may be misunderstanding you, but I mean, once the patient's sedated, that's when this equipment is used.
And the protocol doesn't say hook up the equipment in the ambulance or somewhere else,
Oh,
does it?
no.
In your understanding of the protocol, is that something that's left to a paramedic's discretion?
Yes.
In your evaluation of what was done, in your opinion, was it outside the protocol or harmful to Mr. McClain to move him to the ambulance first?
No.
Did you observe, were you able to observe the transport or some of the transport of Mr. McClain to the ambulance?
Yes.
Could you tell from your own observation whether Mr. McClain was continuing to breathe on the way to the ambulance?
The only part I could see is right before they wheeled him away, and I did observe that he was still breathing.
Did you review any materials or see for yourself on body cam that Mr. McClain ever stopped breathing before he reached the ambulance?
I never saw that.
Did you read anything that indicated he had stopped breathing before he reached the ambulance?
No,
Were you able to review reports regarding the care of Mr. McClain once he was in the ambulance?
yes,
From your review of all of the reports regarding what happened in the ambulance, do you have an opinion of the care he received in the ambulance and afterwards?
looking at the reports, he received great care in the ambulance.
And in your opinion, did Fire Medic Cooper and Lieutenant Cichuniec comply with protocol after Mr. McClain was moved to the ambulance and subsequent to that?
Yes,
Did you observe, Ms. McKinley, Elijah McClain completely on his stomach ever?
I personally never saw that.
Did you observe Mr. McClain in different positions during the body-worn cameras you saw?
I did.
How did that occur?
I'm not understanding the question.
How did he get in different positions?
He was constantly being shifted by the police officers.
Did you observe Mr. McClain to move himself?
Yes,
Based on your review of all the materials that you reviewed, including body-worn cameras, did you form an opinion whether Medic Cooper and Lieutenant Cichuniec acted outside of their protocols that evening?
no,
Do you have an opinion whether what they did, their actions that evening, were within the standard of care for Aurora paramedics in 2019?
yes.
And what's your opinion?
My opinion is that they acted appropriately.
I started asking you some questions about post-administration of ketamine. Do you recall that?
I recall.
Okay. And what, according to the protocol, is the first thing paramedics are supposed to be doing after administering ketamine?
Just observing.
Okay. And you testified to make sure the patient is sedated, is that right?
Yes,
After the patient is sedated, what does the protocol instruct to do?
to get the patient into the soft restraints, positioned into the soft restraints, and then into the ambulance for assessment.
And the protocol instructs on the assessment to be done at that point, is that right?
That's correct.
And that includes hooking up various equipment?
Correct.
Does that include reassessing the ABCs?
Yes.
And leading and also cumulative.
I'll sustain the leading objection once again.
Okay. What is the assessment that the protocol tells the paramedics to do post-administration of ketamine?
Okay, once the patient is sedated, they are to be put in the 4-point restraints. Once they're in the 4-point restraints, Then they are to be reassessed with entitled CO2, cardiac monitor, and a reassessment of vitals.
And what is the purpose of that equipment that you just referred to?
Is that including the restraints or?
Leave out the restraints for a moment.
Okay.
Is it fair to call that monitoring equipment?
Yes.
All right.
Well,
What's the purpose of the monitoring equipment you just
The
described?
purpose of the monitoring equipment, the entitled CO2 is just to make sure that the sufficient air is being moved, and that the CO2 is being blown off. The cardiac monitor is just to evaluate the heart and or the pulse. And then some monitors you can take a blood pressure from.
Is that People's Exhibit 225, 219? I'm showing you what's been marked as, or what's been admitted as People's Exhibit 219, Ms. McKinley. Do you recognize this?
I do.
And what is this Exhibit 219?
It's thank you. It's the agitated combative tracing protocol for the Aurora Fire Department.
Okay, you might want to slide that microphone over closer to you because you're a little closer to the screen now. There you go.
These microphones are directional, so if it's pointed off a different direction, we'll catch it.
And Ms. McKinley, I was asking you about after administering ketamine. You recall that?
I do.
All right. And would that put us down to this box right here? Give ketamine? That's the box about administering ketamine, correct?
Correct.
The blue box. And the protocol goes from there. Is that fair to say?
Correct.
All right. What's the next? Have you reviewed the restraint protocol as well?
I have.
What does that pertain to?
That pertains to putting the patient in full partner class.
In this case, prior to being placed in the soft restraints, what was on Mr. McClain prior to that?
The handcuffs.
Police handcuffs?
Correct.
From your observation, did those have to be removed before the soft restraints could be put on?
Yes.
And then after the restraint protocol, where does the protocol indicate the paramedic goes from there?
It goes to the reassessment of the patient once restrained. It goes to, like I said, the ABCs, the vitals, the cardiac monitoring, and entitled CO2 monitoring.
Okay. Does the protocol indicate where the ABCs post-sedation should be done, where that reassessment should be done?
No.
Does it particularly set forth when it should be done?
It just says after the sedation is achieved and after the patient is restrained.
Okay. You testified about, well, I don't know if you testified about the cardiac monitor. What's the cardiac monitor?
What is it particularly?
Yeah.
Yes, it shows you a patient. It can show a patient's heart rate. It can show a patient's heart rhythm.
The SpO2, what does
Yes.
that mean?
That shows the oxygen saturation in your blood. That's the little probe that goes on your finger.
Okay. And then capnography, what is that?
That's the entitled CO2 that just shows whether the patient is appropriately blowing off their CO2.
High flow O2, what's
Yeah,
that?
that's oxygen.
Start 2 large bore IVs as soon as may be safely accomplished. What is the purpose of that?
Just to have an access point and in case you need to give fluids or other medicines.
Did you observe whether or not paramedics Cooper and Cichuniec followed the protocol in this regard for this particular box?
Yes,
And did they?
yes.
Cole, could we put up Exhibit 219? I'm sorry, 225. I had 219. I don't need that yet. Ms. McKinley, are you able to see this Exhibit 225?
I am.
And does this specifically relate to ketamine?
It does.
All right, I'm going to drop down on this if we could. Down to special considerations. Now, this is one of the protocols that was in effect in Aurora, Colorado in August of 2019. Is that correct?
Correct.
And this one specifically relates, I shouldn't ask it that way. Is this the one that specifically relates to ketamine?
Yes.
Under special considerations, does this section deal with transport and things that happen after sedation?
Leading.
I'm just directing her attention at this point.
I'll overrule the objection. The witness may answer.
Can you actually?
Does this section deal with is this dealing with post administration of ketamine?
Some of it, yes.
Okay. I asked you about specifically what the protocol said regarding after sedation and when the particular equipment must be hooked up. Does this protocol deal with that?
It does.
And specifically, what does it say about hooking up the cardiac monitor and the capnography and the pulse oximetry?
It just says it's to be hooked up once the patient's sedated.
And what does it say at the end of the sentence?
Doing transport
Okay. Transport is what?
when they're on the way to the hospital.
In your opinion, Ms. McKinley, the cardiac monitor, the capnography, the pulse oximetry, was hooking that up in the ambulance outside of the protocols?
No,
Why would you not hook it up immediately after sedation?
Asked and answered several times.
Response.
Judge, I asked specifically about it being in the protocols. I'm now asking her why shouldn't that be done immediately afterwards?
I'll allow what we are starting to circle.
Why would you not hook that up immediately after given ketamine?
you have to wait on sedation to take place.
Why would you not bring the equipment to the patient's side?
It would take just as long for somebody to go back to the ambulance, gather it up, then come back, hook it up, then go back to the ambulance.
In your opinion, was it an appropriate use of discretion to move Mr. McClain to the ambulance first?
You said, was it appropriate or inappropriate? I'm
That
sorry.
an appropriate use of discretion?
Inappropriate. Yes, sir.
Was that decision, in your opinion, consistent with the standard of care?
Yes.
Did you see any decision or action made by the paramedics that evening that you thought was outside, your opinion was outside the standard of care?
No,
Given the two protocols we were just looking at, or any other protocols you reviewed, was there anything in there requiring this equipment to be hooked up prior to administration of ketamine?
no.
Is there a reason not to hook up the equipment prior to administering ketamine?
Yes.
What is that?
It depends on the patient. If they're actively struggling, especially in police custody, then the scene is not quite secure yet.
Does this equipment have wires on it?
Which particular equipment?
Capnography, pulse oximeter,
Oh,
cardiac
yes.
monitor?
Yes.
How does, you said you saw Mr. McClain was still moving around, is that right?
Correct.
How does that interact with the equipment? Or does it?
It doesn't.
Okay. How would the concern about the wires, how does that play in?
I mean, you're asking as far as hooking up the equipment?
Correct.
If you hook all this equipment up and he's still moving around, it could get disengaged, it could get damaged. I mean, it could get stepped on. It's a number of things.
Can you get an accurate pulse while somebody is in handcuffs?
It depends.
Okay. On what?
It depends on how tight the cuffs are. It can. It depends on how much they're moving. You know, depends on their perfusion. It depends on a lot of things.
In your opinion, was it outside the standard of care for Fire Medic Cooper to not take Mr. McClain's pulse prior to the administration of ketamine?
I'm not quite understanding what you're asking.
Okay, in your opinion, was it outside the standard of care? Was it a deviation from protocol for Mr. Cooper to not take Mr. McClain's pulse?
Objection, both leading and the experts. Beyond the experts, sorry, Your Honor, I'm very quiet this morning. Beyond the experts' expertise, that would go to assessment.
Sustain.
The pre-administration of ketamine, or post-administration of ketamine, did you see anything that was outside the standard of care?
No.
Thank you, Ms. McKinley. I don't have anything further.
On behalf of Mr. Cichuniec.
Thank you, Your Honor. I think just a question or two. Good morning, Ms. McKinley.
Good morning.
You testified during my colleague's direct examination that choosing to move Mr. McClain to the ambulance rather than bringing the equipment to him was both within protocol and did not harm Mr. McClain. You recall that?
Objection leading.
It's foundation and it's cross-examination, Your Honor.
All right, the court will allow it if it's cross-examination.
Do you recall testifying to that?
I do.
And can you explain to the jury why the decision to transport Mr. McClain to the equipment rather than bring the equipment to Mr. McClain was within protocol and caused him no harm?
Sure, certainly. I think it took less time to just load him up and take him straight to the ambulance. As I stated previously, going back to get equipment would take some time. Gathering it all up and bringing it back to Mr. McClain would take some time. Then hooking it up and getting it going and then getting him back to the ambulance would take more time than just taking him straight to the ambulance.
And as an expert emergency medical care provider, time is always of the essence when you're treating somebody for a medical emergency, right?
Yes.
I could have just a moment, Your Honor.
Yes.
Thank you, Ms. McKinley. I don't have any further questions, Your Honor.
Cross-examination.
I wanted to return back to that topic we were talking about a moment ago on voir dire. Am I understanding you correctly that Mr. Ludwig has not ever advised you on how to do these types of expert reports?
Okay, maybe I'm misunderstanding what you're asking.
So has Mr. Ludwig previously provided you advice on how to do these sorts of expert standard of care reports?
Yes,
And he's previously provided you examples or templates of reports that he's used in the past so you can follow those templates.
correct.
And you did that in this case. You used a template provided to you by Mr. Ludwig.
I did not use a template.
Did you use one of your own old reports as the template?
I used, if you're speaking to the standard section, then yes.
Okay. And also the layout of the report is something that you borrowed from Mr. Ludwig.
I don't know if I would say that. I have different reports that look different ways.
Well, could we please show to the witness the first page of both her report and Mr. Ludwig's report? These look basically identical in terms of format, right?
I mean, they don't look identical to me. I mean, they look similar.
Okay. And that's because you built your report structure off of what you got from Mr. Ludwig.
I started doing expert witness work in 2019. So yes, my format does not change generally.
And I'm not asking about when you started. I'm asking
Mhm.
about where you got this format from. This is a format you got from Mr. Ludwig.
In 2019, if that's the example he gave me, then yes.
We can go ahead and take that down. Ma'am, what is your hourly rate in this case?
I think it's 275.
Do you know about how many hours you've worked on the case in total?
I can't speak on hours. I can't be sure.
Do you have a rough estimate to give the jury an idea about how much time you've spent working on the case?
I know how much I've made on the case. I can't say how many specific hours, I'll be honest with you.
Okay. How much have you made on the case?
Total to date, about 13,000.
Now, you testified that your opinions are confined solely to what happens after the Aurora Fire Department shows up, right?
The majority, yes.
But in your report, the only quote that you have from Mr. McClain is his quote saying, "I intend to take my power back." Is that right?
Correct.
That happened before the fire department got there.
Correct.
They didn't get told about that statement.
That's what I listened to on the body cam.
The Aurora Fire Department was not told about that statement.
I don't know if they were or not.
You're not aware of any indications that they were ever told about that statement.
No,
Okay. So to the best of your knowledge, that statement could not have in any way affected the paramedics' actions.
no,
The reason you chose to use only that one quote from Mr. McClain, "I intend to take my power back," was because you wanted to emphasize in your report how scary Mr. McClain was.
no,
Well, you chose, for example, not to include the statements from Mr. McClain that happened when the paramedics were there, like, "Please help me." You chose not to include that statement, right?
I did not hear that statement.
You chose not to include the statement from Mr. McClain when the paramedics were there, "I can't fix myself."
I didn't feel it was necessary to use it.
You felt it was necessary to use the statement that the paramedics didn't hear, didn't know about, and didn't affect their decisions, but you didn't think it was necessary to talk about the statement, "I can't fix myself."
Correct.
You also didn't include Mr. McClain's statement, "I'm trying," while the paramedics were there.
Correct.
You certainly didn't include any of his other statements from before the paramedics, like, "I'm an introvert. Please respect the boundaries that I am speaking."
Correct.
You gave some testimony a few moments ago about how the proper weight dosing that they were trained on was this 300, 400, 500 thing, right?
Correct.
Now, ma'am, you're aware that Mr. Chambers trained them that that 300, 400, 500 is just a starting point on how to look at people's weight, right?
Yes,
You didn't mention on direct that this was just a starting point, did you?
I took that to mean that if you didn't know a patient's actual weight or they couldn't communicate it, that's the scale that you use.
Now, my question is, when you were talking to this jury a moment ago, you didn't mention the fact that that was only a starting point.
That's what I took a starting point to mean. That was my opinion of what a starting point is.
But you didn't discuss the starting point with the jury a little bit ago when you were on direct examination. Correct?
I discussed it the way I was asked to discuss it.
Now, another obvious way you can figure out somebody's weight is to ask them, right?
That's one way.
Yeah. Now, in this particular case, Mr. McClain was never asked his weight by the paramedics.
Not that I heard, no.
So he never had an opportunity to tell them that he only weighed 143 pounds.
I can't speak on that. I mean, he was never asked. That's all I can verify.
And the decision not to ask him and to instead just estimate the weight visually, that was made by the defendants here.
Are you asking me a question?
Yes. The defendants here are the ones who chose to visually estimate his weight rather than to ask.
Correct.
We were asked some questions about the agitated patient protocol. Could we please publish that to the jury, exhibit 219. Now, ma'am, on direct, you were asked the question of whether ketamine was the only medication indicated on this protocol, and you said that it was. Is that correct?
I thought I was asked, was it the only medication for excited delirium?
Okay. And that's an important distinction because this protocol does provide for another medication route besides ketamine, right?
On the excited delirium side, I don't see another medication.
Right. On the excited delirium side on the right, ketamine is the only one.
Correct.
But if you go down the left, it's benzodiazepines, correct?
Correct.
Now, with regards to this protocol, you were asked some questions about this section down here. If we could focus in on the complete restraint protocol and this bottom part here. Now it says reassess the ABCs post sedation. When we talk about reassessing the ABCs, we're talking about making sure somebody's airway is clear, right?
Correct.
And when we talk about breathing, we don't just mean, are they breathing? We mean the quality of their breathing, right?
It depends on the situation. Yes, but breathing is generally, are they breathing? Are they moving air?
Okay. And it can sometimes be really important whether it is good quality breathing or not, right?
You can.
Yeah. If somebody's breathing really poorly, that can be a sign that they're facing respiratory depression.
It can.
It can be a sign that there's a pending respiratory arrest coming.
It can.
I mean, somebody who is breathing really poorly, that can be a sign that their life is at risk.
It can if they're breathing poorly.
Okay. When we talk about reassessing the C post-sedation there, we're talking about circulation, right?
Correct.
And not just do they have circulation, but specifically here we're talking about their pulse, for example. Right?
That's one way.
A pulse can reveal, for example, if somebody is tachycardic.
Correct.
It can reveal whether or not somebody has an arrhythmia in their pulse.
It can.
It can also reveal if somebody's pulse is really faint and they're in big danger.
It can.
Now, these next two lines talking about SpO2 and capnography, how they must be initiated. You're aware that the monitoring devices for those are also available on the fire engine, right?
That's what was told to me, yes.
And that they're available in a portable form that could have been brought to the patient.
Correct.
You're also aware from reviewing the timeline in the patient care report and the body camera footage that the defendants were on the scene with Mr. McClain for 5 or 6 minutes before they gave him ketamine.
I don't remember the exact time.
And you're aware that during the time that they were there, they didn't have anybody get those materials from the fire engine.
That's correct.
Now it says here in the box right above this to also complete the restraint protocol. Is that another thing that you reviewed and testified about?
Correct.
Actually, before I turn to that, I want to discuss a couple more things about post-ketamine monitoring. On direct with Mr. Lowe here, I heard you say time is always of the essence. Is that correct?
Yes.
And that's particularly true if somebody's been given a sedative like ketamine, right?
Correct.
Because ketamine has some well-understood side effects like hypersalivation, correct?
Correct.
It also has the well-known side effect of vomiting.
It can, yes.
And hypersalivation and vomiting, if those are not,
They can partially obstruct.
can't clear their airway, they can even fully obstruct someone's airway.
I can't speak on that. I guess it could.
Well, there's also a danger with both hypersalivation and vomiting when you've been given a sedative like ketamine of aspiration, where somebody breathes those materials into their lungs.
Correct.
And so when you say time is of the essence, it's important to detect those things as soon as possible to prevent them from causing medical complications.
That's correct.
Right, if we could please turn to Exhibit 225, the ketamine protocol. Now, this was another protocol that you reviewed in the course of this case, right?
This is a medication. Yes.
And this protocol indicates in the second section there, onset and duration, that ketamine typically takes effect quickly, within 1 to 5 minutes.
Depends on the patient, yes.
And that the indications are that it should be used when the safety of the patient or the providers is of substantial concern, right?
Correct.
I want to talk about how this protocol tells us to deal with the side effects. If we could go down to the side effects section, it talks about laryngospasm in the first one, but then also gives some advice on what to do after administration of ketamine. It says, after giving ketamine, prepare to provide ventilatory support, including bag valve mask ventilation and suction, right?
Correct.
And that's important anytime you give ketamine, right?
Yes.
Specifically, the bag valve mask ventilation is important because respiratory depression is a well-known side effect of ketamine.
In extreme cases, yes.
And by extreme cases, you particularly mean when somebody gets too much ketamine, they're at a higher risk of respiratory depression.
They can be. It depends on the patient.
The protocol here also says that they are to apply cardiac monitoring, capnography, and pulse oximetry once the person is sedated, right?
Correct.
And this applies to every time you give ketamine.
Correct.
It says that these are supposed to be applied once the patient is sedated, right?
Correct.
Not that you should wait until you get into the ambulance to do it.
Well, that's not specific. It's just once they're sedated.
And as you just said, time is of the essence. So you want to get these in place as soon as you reasonably can once somebody is sedated.
Exactly, as soon as you reasonably can.
Now, I want to take this one down and let's go to a little bit of your testimony about that on direct. You were asked whether the suction and capnography was in the ambulance. You said that it was, right?
Correct.
Now, that wasn't the only place it was available, right?
I'm not sure what you're asking.
It also would have been available from the portable kits on the fire engine, right?
Well, I don't know if the fire engine carries suction.
Okay, so that's not a material that you reviewed to see whether they had suction on the ambulance or not?
Okay, I can't recall.
You were asked whether it was harmful to Mr. McClain to move him to the ambulance first before doing any of these monitoring steps, and you said no, right?
Correct.
Ma'am, you're aware that Mr. McClain went into respiratory arrest between getting the ketamine and getting into the ambulance, right?
Judge, I object. This is calls for speculation on this witness's part.
Response.
She's either aware of what happened medically to him or not.
All right.
It's also a point of dispute in this case. It's assumed facts.
Well, if the witness was made aware of it, that's fine. She can answer. If she doesn't remember, that's fine too. So I'll allow the question.
I'll be a little bit more specific with my phrasing, ma'am. In between getting the ketamine
Mhm.
and when they applied the monitoring equipment to Mr. McClain, he went into respiratory arrest.
Okay, I thought your question was that I was aware that he went into respiratory arrest between getting the sedative and before getting into the ambulance. I may have misunderstood you.
Sure. So I'll clarify. You're aware that between getting the ketamine and the monitoring equipment being placed on him in the ambulance, he went into respiratory arrest.
I read that on the patient care report. Yes.
You're also aware that when you look at Mr. McClain on the gurney, he's clearly experiencing respiratory depression.
I can't say that he was or wasn't.
Well, are you aware that his rate of breathing went from about 40 breaths per minute while he was on the ground to only about 12 when he was on the gurney?
12 is sufficient.
That sort of dramatic collapse in somebody's breathing rate is concerning.
As a medic, it's not concerning to me.
It would not be concerning to you if one of your patients went from 40 breaths per minute down to 12?
If I had sedated him, no, sir.
When somebody goes down to 12 breaths per minute and they've been given ketamine, there's also a concern that there may be ineffective breathing due to aspiration, right?
Judge, I'm going to object. This calls for speculation.
The court would find this is starting to go beyond the witness's qualifications to testify and opine.
So it's fair to say that from that respiratory arrest at the least, Mr. McClain experienced dramatic harm between when he was given ketamine, between when he was hooked up to monitoring equipment.
Objection. This calls for speculation by this witness. She's not qualified to testify again.
Response.
I think she is qualified to say whether respiratory arrest is dramatic harm.
Could ask her that question.
Is respiratory arrest dramatic harm?
Dramatic harm?
Dramatic or
Oh, dramatic harm. Okay.
I'm gonna object. That's vague. What is dramatic?
Rephrase, I guess.
is respiratory arrest serious?
Yes,
Is it life-threatening?
yes.
Is it harmful?
I can't speak on if it's harmful or not.
You can't even tell this jury whether respiratory arrest is harmful to someone?
I mean, I don't know what you mean by harmful. Respiratory arrest can be managed, but it can lead to cardiac arrest, yes.
Let's talk about Exhibit 208. Could we please publish that to the jury? Now, this restraint protocol is the protocol that's referenced from the agitated patient protocol, right?
Yes, sir.
After you give somebody ketamine, you're supposed to use this.
Yes,
And in addition, this restraint protocol applies any time that you're restraining a patient.
correct.
And so that's why it says under that indications A in the last sentence that first you're supposed to try alternative methods first, e.g. verbal de-escalation should be used first if the situation allows, right?
Yes, if it allows, yes.
And that's important because if you can just talk to somebody, then you can potentially prevent using more force.
In some cases, yes.
Sure. To find out whether verbal de-escalation would be successful, though, you have to actually try and talk to somebody.
It depends.
If you haven't tried to talk to somebody, you don't know how they're going to respond.
It depends.
If somebody is speaking coherent English, you would assume that they would be able to respond to verbal de-escalation in some way.
I can't say one way or the other. That's patient specific.
Now, in paragraph C, it describes when restraints may be indicated for patients who meet the following criteria. And this idea is repeated in point 2. A patient who exhibits violent, combative, or uncooperative behavior who does not respond to verbal de-escalation. This is saying that the restraints are appropriate only if the person's not responding to verbal de-escalation, right?
That's what it says, correct?
Okay. And this applies in every case where restraints are being used.
Correct.
You didn't see any attempts by either of these defendants to verbally de-escalate with Mr. McClain.
I did not see that. I only saw the police officers trying to de-escalate.
Now, under precautions in point B, it reiterates this idea that restraints should be used only when necessary. And then that concluding sentence is that they may not be used as punishment or for the convenience of the crew. Now, that's important because we don't want our fire department to just be restraining or sedating people because it makes things easier.
I agree.
They should only be using restraints, whether we're talking about physical restraints or chemical restraints, if it's medically necessary.
I don't agree with your chemical restraint. I don't understand what you mean by that.
Okay. They shouldn't be using any restraints unless the restraints are medically necessary.
Unless they're indicated by behavior, yes.
Right. Not just because it might make things easier.
Correct.
Now in point E, it says, do not restrain the patient in the prone position or any position that impairs the airway of breathing. That's important because in the prone position, it's hard for somebody to expand their chest, right?
Correct.
It's hard for them to get deep and effective breaths that they need in order to recover.
Yes, it can be, yes.
The prone position can also increase the risks of aspiration.
It can.
And that's why it says to avoid any position like prone that impairs the airway or breathing.
Correct.
Now, under technique, in point A, the very first thing says, treat the patient with respect. Attempts to verbally reassure or calm the patient should be done prior to the use of restraints. To the extent possible, explain what is being done and why. And that's important because that really affects sometimes how the patient reacts to what's happening to him.
This patient specific, but yes.
Now, you didn't see any attempts by either of the defendants here to reassure or calm Mr. McClain prior to their use of restraints.
Are you asking me,
Yeah.
did I see?
You didn't see any efforts by either of these defendants to verbally reassure or calm Mr. McClain.
He was still being engaged by the officer, so no, I did not see that.
You didn't see any attempts by either of these defendants to try to explain to Mr. McClain what was being done to him and why.
Due to him being engaged with officers, no, I did not.
And ma'am, to be clear, the fact that somebody is in handcuffs with officers does not preclude you from talking to them.
It depends on the patient. If they're actively struggling and being violent, it plays a role.
No matter what a patient is doing, you can always at least try to talk to them.
That's case specific. It depends on the medic and what they want to do at that time.
Well, it definitely depends on what they want to do, but I'm just saying physically, from your training and experience, you could always at least try to talk to somebody. They might not respond, but you can try and talk to them.
I guess one could, yes.
And then in point E on the technique for restraints, it says, during the time that a patient is in restraints, continuous attention to the patient's airway, circulation, and vital signs is mandatory. Now, this doesn't say when a patient's in restraints, wait until they get in the ambulance to do those things, does it?
This is case specific, but yes.
Ma'am, this says it's mandatory, not that it's case specific.
I mean, protocols are guidelines for us. So it depends on the situation, whether it's done. I mean, the vital signs were done eventually. Yes.
And this doesn't say eventually, does it? It says continuous attention to the patient's airway, circulation, and vital signs is mandatory, right?
Correct.
This use of the word mandatory, this is the only time that the word mandatory is used in this whole protocol.
I'm not sure if it's used anywhere else, but here that I'm reading, yes, I do see it.
Now below this, it talks about documentation. And in point B, it says document efforts to de-escalate prior to restraint. It's important for paramedics to write down their efforts to de-escalate so that they can track their compliance with this policy, right?
Depends on the patient, yes.
Well, ma'am, the documentation applies to every patient, right?
Well, documentation within itself applies to every patient, correct?
And so they're supposed to document any attempts to de-escalate prior to restraint so that we can see whether they're complying with the protocol.
Judge, I wonder if this might be time for a stretch break.
I would appreciate that as well, Your Honor, actually.
Well, I think it's actually probably a pretty good time for the mid-morning break. So Anything before we get restarted?
Remember if he, after last week, he was sleeping almost every day. I didn't notice yesterday. It's pretty well, we just saw him. Wanted you to be aware.
Okay. Anything else?
Just to supplement that record that we have noticed Jerder 50 sleeping, but also I think we've caught it very quickly every time. So I think he's actually been awake for basically the entire testimony.
All right, well, I'll try to pay a little closer attention. I'm trying to pay close attention to the testimony. But if anybody notices, if we could just do a stretch break, I guess. Yeah, why don't we have the witness come back up to the witness stand? Just gonna need to wait a second. All right, our jurors have returned. Please be seated. And if we could have the witness back on the witness stand. All right, Ms. McKinley is on the witness stand, still under oath. Once Ms. McKinley is seated, you may continue with your cross-examination.
Thank you, Your Honor. Ma'am, I wanted to wrap up my questions with you, just following up on what we were talking about there. How the protocols and the training deal with the positioning of a patient. Now, on the restraint protocol that we just saw, it said, do not restrain the patient in the prone position or any position that impairs the airway or breathing. Right?
Correct.
That idea is also reinforced in the ketamine training slides, where it says patients should never be kept or transported in a prone or hobbled position, right?
Correct.
The reason that these things get repeated in paramedic training is because they're so important.
Correct.
Now, if we could please publish to the jury Exhibit 105, Officer Green's body-worn camera, starting at 01:49. And just don't start playing yet. Oh, sorry, I have the wrong still. Could you back up just 1 second so we can see Mr. McClain? Oh, sorry, 39, not 49. And then just hit play till we can see him.
All right. We got 500 Ketamine. Yep. Awesome, playing too. All right.
Now, Ms. McKinley, on direct, you testified, I never observed him completely on his stomach. Is that correct?
Correct.
It sounds like some awfully careful phrasing, not completely on his stomach. Is this the position you were referring to when you said that?
Out of several, yes.
Okay. And the reason you said I never observed him completely on his stomach is because here he's pretty close to completely on his stomach.
I can't tell from that angle.
Okay. Well, his right shoulder, well, his left shoulder is down on the ground. We know that, right?
I can't tell from that angle.
Okay. His right shoulder is pretty close down to the ground.
Once again, I can't tell from that angle.
Ma'am, if you can't tell from the body-worn camera, then how could you have offered the opinion before that you never observed him completely on his stomach?
Because I saw it from another angle.
Okay. Which angle did you see it from?
It looked like more of a downward front view of him.
Okay. So from the officer's standpoint, who is sort of in front of him looking at his head?
I can't be sure on which camera it was, sir.
Okay. Let's switch over then to Officer Ward's camera, which is exhibit 111. I think it should be timestamp 5930. No, 5909, I think would be about right. Oh. Exhibit 112, not exhibit 111, my mistake. Is this the view that you were talking about from Mr. McClain, looking down at Mr. McClain's head?
I can't really tell from this particular still.
Okay, let's go ahead and play.
Right there, you don't have to pressure until we move.
Is this the view that you were talking about where you can see Mr. McClain's head and shoulders?
I don't think it was. It was more of a frontal view of him.
Okay, so it's not this view and it's not the one we looked at before. Do you know whose camera you're thinking of?
I'll be honest with you, I can't be sure of whose camera, but are you saying he's prone in this position?
Well, let's first define that term. Prone means when somebody is primarily on their stomach, right?
Prone means stomach down, chest down, and shoulders down.
Okay,
That's what I understand prone to mean.
so, and by shoulders down, you mean both the left and the right shoulders down near the ground?
On the ground.
Okay. And then on their side, or the recovery position would be if their left shoulder is on the ground and the right is in the air.
Yeah, I observed Mr. McClain to be in a left lateral recumbent position, and his left shoulder's on the ground, his right shoulder's up, and I could see that his chest was clear of the ground, and his abdomen was clear of the ground in the shot that I'm referring to.
Okay. Now that left lateral recumbent position, that's when left shoulder down, right shoulder up.
As long as it's up off the ground, yes. I mean, sometimes they call this a Sims position where they have not fully prone, but semi-prone. So as long as they're not fully prone where they can expand their chest and belly, so it's not considered prone.
Now, the more somebody's shoulder bends down towards the ground from that left lateral recumbent position, we enter a semi-prone state.
That's what they say, but they're just saying that they're facing downward is what that means.
Okay. Now, the more somebody's right shoulder moves down towards the ground, that's the more pressure that's on their chest, right?
If their chest is not touching the ground, I don't agree with that.
Okay. And if their chest is touching the ground, the further it moves down, the more pressure that's on their chest.
If it's flat on the ground and their belly is flat on the ground and their shoulders is flat on the ground, they're either face down or head turned to either side, that's prone.
And I'm not asking you for this definition of prone. I'm saying as somebody moves closer towards that prone position, that's more pressure on their chest.
I can't say that that's true.
Okay. Now, as somebody gets closer towards that prone position, it makes it harder for them to expand their diaphragm and breathe.
I can't testify to that.
And with regards to Mr. McClain's position here, my understanding is that your testimony is that he's not completely prone, but he's real close.
I'm just saying he's not prone.
But he is really close to being prone.
Jack, that's been asked and answered.
Sustained.
That's all the questions I have for you, ma'am. Thank you.
You're welcome.
Redirect.
Ms. McKinley, did you ever see Mr. McClain in a position that you believed was impairing his breathing?
No,
You were asked on cross-examination about his breath rate going from 40 to 12. Do you recall that?
yes,
You were asked whether that would concern you as a paramedic. Do you recall that?
yes.
Why would that not concern you as a paramedic?
Well, that wouldn't concern me because it's more concerning for the breaths of 40 than it is the breaths of 12. 12 is considered normal. It's what we give doing cycles of CPR, and is what some people breathe regularly.
And did the breath rate go from 40 to 12 after Mr. McClain was sedated?
Correct,
Would you expect that with the sedative?
correct.
Is that the purpose of a sedative, among others, to slow breathing?
It's to calm the patient, if that's what you're asking.
In calming the patient, what effect does that have on somebody's breathing?
It can slow their breathing, yes.
You were asked on cross-examination, from your training and experience, you can try to talk to a patient at the scene. Do you recall being asked that?
I do.
In your experience, have you had adverse things happen in trying to talk to patients?
Yes,
Relevance to her personal experience.
Judge, this is following up on the question asked in cross.
All right. Yeah, it's outside of the scope of the question that was asked.
Judge, may we approach briefly so I can clarify the court's view?
Okay.
In your experience, Ms. McKinley, have you attempted to talk to patients you believed had excited delirium?
Same objection, Your Honor, as to relevance of her specific experiences that are different than this situation.
Well, why don't you ask a different question? I'll allow it.
Okay. In your experience, Ms. McKinley, have you talked to patients who were suffering from agitated patient or excited delirium?
Same objection. That's the exact same question.
I'll allow that question.
yes,
Have you had varying results when you do that?
Objection to relevance as to what the results of trying to talk to different patients in different circumstances are.
This was gone into in cross. I'm not reading, Your Honor.
I'll find that it's within the scope of the cross based upon her experience.
Have you had varying experiences when you try to talk to a patient who is suffering from agitated patient or excited delirium?
yes.
Can you describe that?
Okay,
Objection to relevance and beyond the scope.
All right, I'm going to sustain that one.
When you say varying experiences, Does it always go one way?
Objection, cumulative, and also to the extent it would invite new testimony, relevance and beyond the scope.
It's not cumulative because I've never been able to ask this question and get the answer.
I'll allow the question, and I might need to hook up a lapel mic for Mr. Slaughter because I'm still having trouble hearing you.
Usually too loud. I will do my best. Sorry.
Okay, thank you.
I asked you when you've tried to talk to patients with excited delirium or an agitated patient, you said you get varying results. Is that right?
Correct.
Is it consistent when you've tried to do that?
No.
In this specific situation, did you believe it was within the standard of care for these paramedics to not try to talk to Mr. McClain?
Yes.
And is that based on your qualifications, your experience, and your training?
Yes.
You were asked on cross-examination about including a quote from Elijah McClain, "I intend to take my power back." Do you recall that?
I do.
Why did you believe that was relevant to include in your report?
That's when I noticed that his real struggle with the officers began.
After making that statement.
Correct.
And why was that important for you or relevant for you to include in your report?
It was a reference point to when things seemed to get out of control with him.
You were asked on cross about not including the statement of Mr. McClain, "I can't fix myself." Is that right?
Correct.
And you heard on body cam Mr. McClain make that statement. Is that right?
Yes.
Why did you choose not to include that in your report?
Mr. McClain was already agitated and aggressive at that point.
Was that a statement to you? Did that statement make sense isolated from what had happened earlier?
No.
You were asked on cross about determining weight. Do you recall that?
I do.
You were asked about 300, 400, 500. What's your understanding of those levels that you were asked on cross about?
Objection to relevance of her understanding of the training.
Sustain.
You were asked on cross about that being a starting point. What was your understanding of that as a starting point?
Objection of relevance as to her understanding of the starting point.
Response.
Judge, she was asked specifically about being able to determine a weight, and she was crossed on that's only a starting point. I believe she should be allowed to express why she thinks.
Well, based upon the protocols and the training from Travis, I'll let you ask the question in that form.
Okay.
So ask the question.
Okay. In considering the training and the protocol, how did you view that instruction on 300, 400, 500?
Objection to relevance of her view of it. All that matters is what the training was, the defendants.
Sustain.
Ms. McKinley, do you have an opinion to a reasonable degree of professional certainty whether following the 300, 400, 500 guideline outlined by Travis Chambers was outside the standard of care?
Objection misstates the evidence. It's not just 3, 4, 5. That's the starting point. Counselors testify.
Overruled.
Can you re-ask it for
Sure.
us?
Do you have an opinion to a reasonable degree of professional certainty whether the paramedics following the 300, 400, 500 guideline outlined by Travis Chambers was outside the standard of care?
Do I have an opinion?
Yes. Was it within the standard of care for paramedics to follow that guideline as outlined by Travis Chambers?
Yes,
You were asked whether another way is to ask Mr. McClain his weight. Is that right?
correct.
In your opinion, was it outside the standard of care to not ask Mr. McClain his weight?
No,
Why?
because of the state that he was in or that he was impressed to be in.
In that circumstance, would you have asked Mr. McClain his weight?
Objection relevance.
Why did you believe that it was within the standard of care for the paramedics to be following the agitated patient protocol?
Because of what they saw when they walked up and during their continued visual assessment.
Did you view or hear anything that led you to think this was not proper to go under agitated patient protocol?
Objection asked and answered a second ago on direct and beyond the scope of my direct. I never asked if they were within the protocol for excited delirium.
Also stated on the first ground.
You were asked about on cross about time being of the essence. Do you recall that?
I do.
In your opinion, did the paramedics act in an appropriately speedy fashion?
Yes,
In your opinion, did they act as though time was of the essence?
yes,
Is it a part of acting as though time is of the essence to have a rapid transport?
yes,
Can you transport a patient who's not in the ambulance yet?
no,
Do you believe it was outside the standard of care for Mr. Cooper not to ask someone to go back to the engine and obtain equipment kits?
no.
Why not?
At that time, I'm going to say that if he would have needed extra equipment, I'm sure he would have asked for it.
Did you see at that point a need for extra equipment?
Me personally, no.
You were asked whether suction and end tidal was available on the fire engine. Do you recall that?
Yes.
You said you didn't know. Is that right?
Well, I can't attest to the suction. Correct.
If you assume that it was on the fire engine, does that change your opinion whether somebody should have gone and got it?
No.
Do you know, Ms. McKinley, whether Mr. McClain went into respiratory arrest first or cardiac arrest? Do you know?
Well, you have to, well, I guess I'm not a doctor, so I can't say which one occurred first, but I would assume,
Objection, speculation.
Sustained. Witness may not assume.
Was there anything that you observed regarding Mr. McClain's breathing until he goes into the ambulance? Was there anything that caused you concern about his breathing?
Objection relevance as to her concerns.
Sustained.
Was there anything you observed that you thought the paramedics should have been dealing with regarding his breathing?
No.
Could we put up Exhibit 219 again? Once, if you could pull it up a little bit, please. Once it's determined you're under excited delirium and ketamine is given, what's the very next thing you do?
You restrain.
You complete the restraint protocol, right?
Correct.
And that involves restraining the patient with soft restraints. Is that right?
Correct.
Did you see anything in that regard that was outside the standard of care for the paramedics?
No.
And can you go up just a little bit higher with that, please? Does the protocol speak to the equipment that we've talked about during transport?
Objection beyond the scope. I didn't ask about that.
A response?
Also cumulative.
Judge, I believe he did go into this area regarding, he put up the restraint protocol, and I'm following from there after the restraint protocol.
Well, okay, you can do so, I guess, according to the diagram.
Regarding the equipment, is it required that that be connected and used during transport?
Maybe I'm confused about what you're asking.
If one makes a determination of excited delirium, does a paramedic have to conclude that someone is a danger to themselves or others?
That's one symptom, yes.
And if the paramedic concludes that one is a danger to oneself or others, does the restraint protocol require restraints be used?
Yes.
Was it outside the standard of care for the paramedics to put Mr. McClain in soft restraints and take him to the ambulance in that way?
No.
In your opinion, was it outside the standard of care for Mr. Cooper to voice what his plan was going to be when he got to the ambulance?
Objection beyond the scope.
Response?
She was asked about what was done post ketamine sedation, and I'm asking about whether the steps Mr. Cooper took were within the standard of care.
You can ask that.
The step of not hooking up the equipment, but instead saying what his plan was that Mr. Cooper did, was that within the standard of care in your opinion?
Same objection and cumulative. Mr. Pello is just repeating his entire direct, asking every variation of activities of care with a tiny little variation.
Gone into on cross-examination, Your Honor.
All right, you can ask whether the standard of care was followed after post-ketamine.
Yes.
Ms. McKinley, are the protocols to be taken separately and consisted separately, or do they exist together?
I'm not understanding your question.
All the protocols we've been talking about and the many more Aurora protocols, are those to be considered by a paramedic as a whole?
The whole protocol?
Yes.
Yes.
From what you observed, was Mr. McClain assessed for ABCs post-ketamine administration?
Yes.
And did that follow the protocol? Was that within the standard of care?
Yes.
Ms. McKinley, did you at any time see anybody with EMS restrain Mr. McClain in the prone position?
No.
Did you ever see Mr. McClain on the video in what you describe as the fully prone position?
No.
You were asked regarding the restraint protocol about other positions that could impair someone's breathing. Do you recall that?
I do.
Did you ever see Mr. McClain in a position that would impair his breathing?
No.
Was visually estimating Mr. McClain's weight instead of asking him his weight within the standard of care?
Yes.
Why? Why is it within the standard of care?
It's something that we do often. If somebody is, like I said previously, engaged with police and seems to be, in this delirium or in this state, then it would be within the standard of care to estimate the weight.
In this situation, do you believe paramedics acted outside the standard of care by not attempting to verbally de-escalate the situation?
No.
Did you see Medic Cooper approach an officer at one point in time and ask a question of him?
Yes.
After asking the question, what was the response of the officer, if you recall?
Okay, I guess it would depend on what question he asked.
A question about whether he knew if he spoke English.
Objection to beyond the scope.
It's beyond the scope, and now we're getting into narration of the video, so sustain.
Why was it appropriate, based on the body-worn camera footage you saw, to not attempt to speak directly to Mr. McClain?
Objection, leading and cumulative.
We're getting cumulative, counsel.
Prior to, I asked you about Mr. McClain's position. Prior to being wheeled to the ambulance, did you ever see him having a failure to breathe?
Not that I can say it with certainty, no.
Did you ever hear him struggling or gasping to breathe?
No.
Thank you, Ms. McKinley. I don't have further questions, John.
May the witness be excused? All right, you may step down. Next witness for the defense.
Thank you, Your Honor.
I do. Thank you. And once again, if you'll tell us your name and last name.
My name is Eric Hill. Last name is Hill.
Your witness.
Thank you, Your Honor. Dr. Hill, it's been a couple of days since the jury has seen you. Can you remind them what you do for a living, please? I'm an emergency medicine physician and EMS medical director. And for what organizations are you an EMS medical director, sir? I'm an EMS medical director for Aurora Fire Rescue, Falk Rocky Mountain, Sable Altura Fire District, Bennett Watkins Fire District, Agate Fire District, and Deer Trail Fire District, and the Medical Center of Aurora. Okay. Prior to becoming a physician, I want to talk to you a little bit about your education. How does one, how does one become a physician? They go to medical school. Okay. Prior to medical school, did you, what was your education? So I did my undergraduate education at the University of Colorado at Boulder. I received 2 bachelor's degrees there. And then shortly after that, a couple of years later, I went to medical school at the LSU School of Medicine in New Orleans. And after medical school, did you complete any medical residencies or internship programs? Yes, I completed an emergency medicine residency at Brooke Army Medical Center in San Antonio, Texas. Okay. Sorry, Brooke Army Medical Center in San Antonio, Texas. And doctor, I think if you can slide that microphone a little bit towards you, that might assist us. Is this better? Yes.
Okay,
And I'll just remind you, I know doctors often dictate fast, but here we just need you to slow down just a little bit for our court reporter. I will do my best. And I will do my best as well, because I suffer from the same affliction. How long was that medical residency program, sir? The emergency medicine residency was 3 years. Okay. And how long was medical school? Medical school is 4 years. And when did you start medical school at LSU? I started August 2002, completed it May 2006. Okay. Now, as a after your medical school and after your residency, what did you do career-wise or work-wise? So when I was in medical school and residency, I was a Army officer, U.S. Army officer. So after I completed medical school, I was active duty military for 7 years. Total 7 years, including that residency. So I had 4 years after medical school as a Army physician. And where was that? Where were you stationed? Where were you? Where did you conduct that practice? So my first 2 years out of residency, I was assigned as a brigade surgeon with the 2nd Brigade 10th Mountain Division, and that was out of Fort Drum, New York. While I was there, 1 year was deployed to East Baghdad during the Iraq War. And then 1 year was back in garrison at Fort Drum, New York. My last 2 years were assigned as a emergency physician at Eisenhower Army Medical Center in Augusta, Georgia, where I was an ER physician and director of their live tissue procedure labs for residents. Have you ever taught on the subject of emergency medicine or emergency medical services? Yes. Can you tell the jury a little bit about that experience?
So I teach a lot. I've taught residents, so resident physicians, medical students, physician assistants. I've taught them extensively, really starting at Eisenhower Army Medical Center and through the last 10 years. I have taught paramedics, both as a paramedic and then now as a physician. I've taught paramedics since 2014 as a clinical mentor. I provided lectures to to paramedic schools. I have done lecturing at EMS conferences in the state of Colorado and other city events that are hosted around the city of Denver.
Okay. As a emergency medical physician, do you belong to any professional committees?
Sure. I mean, you're referring to organizations or committees or?
Well, I believe you list on your curriculum vitae professional committees. And so I was asking, but we can expand that to committees/organizations. Yes.
Okay, so I'm a fellow of the American College of Emergency Physicians, which is a professional organization it's a college for emergency medicine physicians. I am a fellow of EMS for the National Association of EMS Physicians. And then in the state, I serve on a statewide Emergency Medicine and Trauma Advisory Council, which is an advisory board to the Department of Public Health.
And how does one get on that committee specifically?
You apply for it, and then you apply, and then you're appointed by the boards and commissions through the state of Colorado to that board or to that board.
Okay. And do you serve any leadership in a leadership capacity in that committee at all?
I do. I serve. I'm the vice chair of this. They call it the SEMTAC. I serve as the vice chair of that council, and I'm the chair of the statewide trauma advisory committee.
Now, when you say SEMTAC, is that spelled SEMTAC?
Correct. State Emergency Medicine Trauma Advisory Council.
Okay. Are there any other statewide boards or committees that you serve on?
We have part of the Denver Metro EMS Medical Director Advisory Group, which is a group of about 26 emergency physicians who write protocols and develop training, or mostly develop protocols for the Denver Metro area agencies.
Okay. We'll get back to that a little bit later. Do you carry any, I'm assuming you're licensed in the state of Colorado.
Yes, I'm licensed in the state of Colorado.
Do you have any other licensures in any other states to practice medicine?
Currently, I also have a license to practice in Louisiana.
Okay. In addition to your licensure, do you carry any board certifications?
I carry 2 board certifications.
What are they?
I am board certified in emergency medicine by the American Board of Emergency Medicine, and I'm board certified in emergency medical services.
What is the difference between emergency medicine and emergency medical services?
Emergency medical services is specifically the delivery of emergency care in a pre-hospital environment, and it's significantly different from emergency medicine, which is why it has its separate board certification.
Okay. Speaking of pre-hospital care, prior to becoming a physician, do you have any experience working as a paramedic or an EMT?
Yes, I do.
Can you tell the jury a little bit about that experience? First of all, when and where you were employed in such capacity?
So I started as a volunteer firefighter with a department called El Dorado Springs Fire Protection District, and that was in March 1995. I continued with them for the next 7 years. In 1996, I joined the Cherryville Fire Protection District, which is like it's like unincorporated Eastern Boulder County. And then I later joined as a full-time, those were all both volunteer positions. And then I became full-time paid firefighter, engineer, paramedic for Boulder Rural Fire Protection District.
Did you work as in emergency medical services during your time in medical school in Louisiana?
I did a little bit of work. So medical school is rather book intensive, and I wanted to keep my, I guess, passion for EMS alive. So I did some part-time work with the New Orleans EMS system as a paramedic with their ambulance system. It was maybe a day a month or a day every other month when I could fit it in between testing and that kind of stuff.
Now, in addition to being the medical director for the Medical Center of Aurora, are you also a practicing emergency room physician there?
Yes, I'm still a full-time emergency medicine physician.
You made a distinction between when you were talking about emergency medical services versus emergency medicine, and you used the term pre-hospital care. Can you explain to the jury what you mean by the term pre-hospital care?
I would define it as all the care that is delivered like in a field environment prior to arrival at an emergency department. So I think it would encompass both emergency medicine, like EMS, which is traditionally what people would think of as 911 response, but also would include things like wilderness medicine or disaster medicine, those sort of things.
Okay. You've also indicated that you're a medical director for Aurora Fire Rescue, Falk Rocky Mountain, and a host of other fire districts or EMS operations. Can you just explain briefly to the jury what a medical director does? What's the role of a medical director?
So a medical director does a few different things that we're required to do. One is we credential the EMS clinicians for that agency. So EMTs, paramedics, we credential them to work in that agency under the protocols we approve. So along those lines, we approve the EMS treatment protocols for that agency. We also are involved in developing EMS trainings and also in the review of calls. So the quality assurance program to review calls for quality of care.
In that capacity, do you sometimes do ride-alongs with your EMS crews?
Yes, I regularly ride along.
Do you do this job alone?
No, well, no, there are 4 associate medical directors who assist me with protocol development, things, quality assurance reviews. We call them the CQI reviews, which is CQI is continuous quality improvement. So we review those calls. They assist me with those. They assist in training development. There's also, EMS chiefs and other sorts of personnel within the agencies, which help with training development and administration of the EMS program.
So all of those folks that you just described, the associate medical directors, EMS personnel, hierarchy within AFR, do they all report to you in that regard?
I don't know what the word report mean. I mean, I'm the overall medical director that it has the overall say of the protocols and development of the system. I'm not sure if I'm not their direct report or something though.
When it comes to medical treatment provided by those organizations, does the buck essentially stop with you?
Yes.
Have you, in your career, either as a paramedic or as a physician, ever administered ketamine?
Yes.
Okay. Have you administered ketamine in a hospital setting?
Yes.
Have you administered ketamine in a field setting?
Yes.
In your experience, either as a paramedic or as a physician, have you ever treated a patient that you determined was suffering from a syndrome called excited delirium?
Yes.
Once, more than once?
That's hard to equivocate. Dozens, I guess, a couple dozen, few dozen. I don't keep track of that.
Okay. Have you ever been previously qualified to testify as an expert in emergency medical services by a court of law?
In emergency medical services? No, I don't believe so.
Okay. Emergency medicine?
Yes.
Okay. Um, Your Honor, at this point, I would tender Dr. Hill as an expert in emergency medical services to include the areas of paramedic roles, protocols, and training, including the use of ketamine and excited delirium.
Board Dyer.
No board dryer, Your Honor, but I do have an objection. Dr. Hill's endorsement in this case is quite narrow. And I'm not aware of any opinions that he could give that are not cumulative of opinions we've now heard from several different experts.
I did have one here, but.
All right, well, we start with yours if you want, and then I'll talk to folks at the bench.
Good morning, Dr. Hill. We're still in morning.
Yes, we are.
I just had a couple follow-up questions. Since your time with El Dorado Fire till today's date, how long would you estimate you were ever kind of away from pre-hospital care?
I don't think I had like probably direct development of any interaction with EMS specifically in their areas of residency. Actually, that's not true. I did a couple months, maybe 3 years total.
So just during that potential time during residency, you might have had a little bit of a hiatus.
Residency, and then in the military, when I was deployed to Iraq, their combat medics are not necessarily paramedics, but I still was involved in their supervision.
Okay, so you supervise the combat medics, which would be the military's equivalent of a paramedic, if for lack of better terms.
Correct.
Okay. And over your lengthy time in medicine, how often would you estimate you've used ketamine?
How many times have I ever given ketamine? 100, 200 times. Like for ketamine has a lot of different indications for it. So in total, I think I probably have ordered it maybe 100 to 200 times.
Okay. And does that include both in the hospital and in kind of pre-hospital settings?
Yes.
Okay. And did that also underlay, as the medical director, was it your job to secure the waiver?
Yes, it was.
And did this training and experience inform you when you sought the waiver for AFR?
Yes.
Okay. And did that training and experience also assist you as you then helped with trainings and ride-alongs with AFR?
Yes.
Okay. I don't have any further questions.
I think the court indicated you wanted us to approach.
I have a better idea,
Okay.
I think. I'm going to have my staff take the jurors back to the jury room for a few minutes because I need to familiarize myself with some things. Don't form or express any opinions or discuss the case, even amongst yourselves. Do no independent research. Let the court know if anybody tries to speak with you about the case, and avoid any press coverage. All right, the jurors have stepped out. I saw counsel holding a piece of paper, or a stack of paper. I'm not sure what it was, but I think I need to be, what's the terminology? Be informed. So I wouldn't mind taking a look at that if that's what we have there is the report. Oh,
And I'm not sure what you're approaching with, so. Oh, which one? There have been several. Okay.
we You can speak up so everybody can hear you.
You can have the podium. I'll see the podium.
Your Honor, I've handed you the expert endorsements of people in both defendants from the deadline on October 23rd, 2023. Dr. Hill was endorsed based on his grand jury testimony, but to certainly exclude any opinions regarding the conduct of the defendants in this case or any post-incident reviews. And I think what that leaves from his grand jury testimony is general standard of care opinions, which we have heard a lot about.
And indicate you a lapel mic too.
Sorry. My throat lozenge job.
Okay. All right, well, let's make sure that everybody is talking about the same thing, I guess. The document that I have reads that Dr. Hill is expected to testify as an expert in the area of paramedic roles, protocols, training, including the use of ketamine and excited delirium. The testimony will include, but not limited to, opinions that he testified to in front of the grand jury. Recorded interview December 28th, 2020, and to ketamine administration protocols and training provided in discovery. The next bullet point says Dr. Hill is not expected to offer any opinions related to the paramedic conduct in this case, nor any post-incident review. So what's our area of dispute, I guess?
All right. So if I can address that, well, was that directed towards me or are we still talking to the AG? I'm sorry. I don't want to jump in.
Well, the counsel for the AG mentioned that the endorsement was pretty limited, and I suppose that depends upon your perspective. So I guess with that, I'll move to your side.
So, Your Honor, as you can tell by and I'm just going to refer to Mr. Cichuniec's endorsement because Mr. Cichuniec is calling Dr. Hill. We cross-endorsed on October 23rd on the deadline, Dr. Hill as a medical director expert as endorsed by the prosecution. The endorsement at that point in time by the prosecution was what you have in front of it minus the second bullet point. Later that same day, I want to say about 3 hours later, we received an amended endorsement that the court has before it. So when we endorsed Dr. Hill, we were operating under the people's endorsement, which I don't think is very narrow. It talks about, first of all, they list him as a medical director. And let me just stop there. Would you like Dr. Hill to step down from the stand?
I thought somebody would ask if they wanted that, but that's fine.
It might be a little uncomfortable for Dr. Hill to hear us talking about him in this fashion.
That's fine. You can step down.
Would you like me to step out into the hallway, sir?
Sure, whatever you would like to do, that's fine. That seems appropriate here.
Thank you, Your Honor. So the people have endorsed Dr. Hill first as a medical director and as an expert, which he has testified that the medical director's role really is in emergency medical services, which is why Mr. Cichuniec has tendered him as an expert in emergency medical services. In addition to the people producing his curriculum vitae, in which it indicates that he is board certified in emergency medical services. So not only do I think there is no surprise or lack of notice to the prosecution because this mirrors their endorsement, but I don't believe it's narrow in scope either. He's board certified in emergency medical services, which incorporates a whole host of things to include, as the people have indicated in their endorsement, the area of paramedic roles, protocols, and training, including the use of ketamine and excited delirium, which is exactly how we've tendered him to this court as an expert. So we have not deviated from the endorsement that has been shared between the parties since well before October 23rd, 2023. The initial updated witness list and expert disclosure minus the second bullet point was provided by the prosecution. Actually, I don't have a date on this. I know it was after May 15th, 2023, because that's when they issued their original endorsement, in which this endorsement is an updated one. And for the court and for the record, the endorsement that I'm reading from was provided by the prosecution and bears discovery Bates number 42371 through 42395. As I indicated to the court, we filed a notice with the court that we were providing this endorsement to the prosecution, provided that endorsement to the prosecution. I believe I want to say, I may not have the timing exactly right, but some 3 hours later, the prosecution filed their notice with the court that they were providing us their endorsements on October 23rd. It is on that date, at that time, that we received the endorsement from Dr. Hill with that second bullet point. I would submit to the court that that because that happened after our endorsement and our intent was to endorse him as endorsed by the people prior to the limitations that you've received. However, in addition to that, I would say that the statement that Dr. Hill is not expected to testify in those areas doesn't rule out that he may or may not. And so I think the Attorney General's argument that somehow the scope of Dr. Hill's expertise or potential testimony has been limited, I don't believe that paragraph indicates that. I think that's reading it too far. Second, it speaks to the limitations that the Attorney General's office might impose on themselves, but certainly should not be attributed to the defense because it occurred after our endorsement was provided, and B, does not indicate that somehow Dr. Hill is not qualified to opine in that area. What I will tell the court is I have zero intention of going into the QA/QI process. I believe the court's prior ruling about subsequent reviews by individuals in this case has been excluded. We have no intention of eliciting any conversations that Dr. Hill may have had with paramedics Cooper or Cichuniec following this incident. But just because he engaged in that QA/QI process does not mean that he can't speak to opinions that he has formed based upon his review of the incident here. He just cannot testify
Looks like we have all the parties in council present. All right, the matter before the court currently is, I suppose, the scope of Dr. Hill's testimony, his direct testimony with respect to, I suppose, the endorsements and the differences in the endorsements. The court would first find that, yes, the court would, I suppose, could determine that the testimony could very well be cumulative, but Mr. Cichuniec has the right to call somebody in the general areas. But any other further argument about the scope of the testimony?
Your Honor, the only thing that one of my esteemed colleagues pointed out that in the endorsement from the prosecution, they indicated that Dr. Hill's expert testimony will include, but is not limited to, the opinions which he testified to with the grand jury in that interview, which seems to be contrary to what they're asking the court to do today, which is limited specifically to that transcript and that interview. I can tell the court that our intent is to elicit his opinions and testimony as the medical director and the author of the protocols in the areas, the subject matters that are consistent with his grand jury testimony and his interview. Do I anticipate him to testify word for word? Of course not. But I don't think the court should limit it that narrowly if it is intending to limit it. I think when we've talked about how whether or not this endorsement is a narrow endorsement or not, I just wanted to point out that.
All right, anything further from the people?
Your Honor, I think if the testimony is fairly within the scope of the grand jury testimony, that's okay. And we wouldn't object to it on those grounds. I think our primary concern is with respect to any opinions that have not been disclosed with respect to the conduct of the defendants. To the extent the opinion they want to rely on about the conduct of the defendants is what is in the grand jury testimony, I think I would also have 702 Shrek objections to that opinion were it to come in addition to the concerns about the tie with the post-incident review problems.
All right, well, this is presumably the doctor going to rely on anything other than the QA/QI investigation with respect to reaching those opinions? I don't know.
It's my understanding that Dr. Hill is going to rely on the information that's provided to him about this case that was provided to him by the prosecution that he learned through the course and scope of his interviews with the prosecution. Obviously, he has access to the protocols. I don't know if they provided all that information to him. You know, he didn't tender a report for the prosecution either. So I suspect that there are things that he has in his general knowledge that has been incorporated as his role as the medical director that may not be able to be traced to either one of us. But I am not going to elicit any opinions about his QA/QI process.
Well, that really wasn't my question. My question was whether or not you're anticipating asking opinions about whatever it is that Mr. Cooper and Mr. Cichuniec did with respect to specifics and standard of care.
I think there very well could be a line of questioning and opinions based upon his review of the body-worn camera in this case, and whether or not that comported with the protocols, i.e. the standard of care. I think that, but I believe that that is consistent with.
No, was that review done as part of the QA/QI process or a separate process?
Well, I would suggest it was probably done as both.
But that it doesn't reflect that in his testimony.
Okay.
It says he looked at the PCRs, the medical records, the monitoring equipment that was attached. There's nothing in there about body-worn camera review.
Well, then certainly they're on notice of his knowledge of that.
Knowledge of what?
Of that review, of with those, the PCR report, the medical records, and he testified to that effect at the grand jury.
Yeah, but nothing about body worn cameras. That's what I'm getting at.
Well, I'm not going to show anybody.
Your Honor, again, I think if he's trying to render an opinion based on the things that he reviewed that are reflected in the grand jury testimony, that would be an unreliable expert opinion. We know what types of materials experts review to give opinions about their defendant's conduct in this case, because we've seen a couple of them. If his review is, I looked at a patient care report and didn't review all the body worn camera and didn't have any statements from anybody to look at, I think that is per se unreliable, and the court should exercise its gatekeeping function to keep it out. It's also undisclosed to the extent he looked at anything else.
All right, we'll have to, I suppose I'll have to rely upon whatever foundation is laid for what he looked at. The court would, I think Mr. Goddard made the argument with respect to the fact that he was, I don't know, kind of endorsed as a medical director. And the court notes that in the testimony before the grand jury, and specifically on pages 10, 11, and 12, his testimony was that the bar, if you will, was a very low bar for being a medical director. That you just had to be able to do the same procedures that the paramedics would be doing and be actively involved, which is undefined. So the court doesn't find that to be sufficient to have Dr. Hill qualified as an expert in the area of, what do we call it?
I think it's emergency medical services.
That's it.
Buzzword.
Would he be allowed to opine and give opinions as a medical director, because that is consistent?
Well, yeah, that's what I was talking about, the medical director. That doesn't imply, at least in the court's view, based upon his own testimony, that there's any expertise in that particular area, other than he can give the same medications the paramedics do.
Well, he did testify that he's board certified. Board certified. Doesn't that certainly that's qualifications greater than.
Well, that's outside of what was in the people's endorsement.
But it's in his grand jury testimony, which is in there.
Well, no, he said board certified eligible in his testimony.
Right, well, is he allowed to testify as a medical director and in his roles as medical director of AFR? I want to ask him about the protocols, where they come from. He authored them. I want him to interpret the protocols. I want him to give opinions based upon his expert opinion in the roles of paramedic roles, or sorry, the areas of paramedic roles, protocols, training, and ketamine training. I'm not serious.
Yeah, there is extensive testimony. I've charted it out. There is some testimony, and I suppose we ought to cross the bridge now since we're there almost. It would occur to the court that the waiver process, that stuff's within the testimony of ketamine training, Mr. Chambers training, AFR Falk reports, hospital records, ketamine specific protocols. And there was some testimony also in that hearing with respect to probably using the wrong terminology because I scribbled, but a general assessment, a secondary assessment, respect to the interview, it's much of the same thing. There's some stuff in there about implied consent. I don't know that I would be allowing that. Primary, secondary, SOAP, Excite, delirium assessments. And then once again, he testified about, he reviewed the PCR medical records and the monitoring data.
So I agree with all that. The only question I think based on the court's record that we should probably talk about is I do think his testimony on his consent and implied consent is an area that I do intend to inquire, but not from a legal perspective, but it's in the protocols of the consent protocol as medical decision-making. So I'm going to ask some questions about decision-making capacity as it relates.
I think as it relates to their training of the paramedics, I think that's,
So I didn't want the court to hear consent and think, that we're going, that's the direction we're going.
yeah, well, there's already some discussion in this trial about those things, and it needs to be crystal clear that these are medical decision-making parameters rather than legal.
Your Honor, I guess on that same note, the actual consent protocol, I think is very confusing on that front. It actually it has the word legal in it. And so this area does give me a lot of concern on 403 grounds that it is going to be very confusing to the jury.
Well, I'll strike it if it's not clear to me, and these are relatively new areas to the court as well, based upon the context of this case. So as long as we're crystal clear that we're talking about medical protocols and medical things and not legal, and I really don't like to interrupt, but if I have to, I will ask them, are you talking about a medical decision or is this legal basis? So.
That's what they know the prosecution and the court will.
Yeah, and to the extent that is necessary, and I mean necessary, I'll allow a little bit of leeway on leading questions, a little bit of leeway. Okay.
You want me to call the witness in first before we return the jury, Your Honor?
That'd be fine. I don't know how long it's going to take for him to get up here.
Okay.
Oh, we're missing one.
Well.
And I received the transcripts from the prosecution. I would love to have them for my reference, but it's probably more important that you have them.
I have a copy. Thank
You have an extra copy? Okay, thank you. All right, the jurors have returned and are being seated. Please be seated, and the court will recall 21 CR 2800 and 2806. At least as, excuse me, at this point, I suppose subject to some amendment, the court will allow Dr. Hill, who's on the witness stand still under oath, to explain and opine in the area of paramedic roles, protocols, training, including the use of ketamine and excited delirium.
Thank you, Your Honor. Good afternoon again, Dr. Hill.
Good afternoon.
I want to start by talking to you about protocols and specifically the AFR and Falk Rocky Mountain protocols, okay?
Yes, sir.
Now, I guess first and foremost, you're the medical director for both of those organizations. Is that right?
That is correct.
And you were so in 2018 and 2019. Is that right?
That is correct.
Okay. So can you tell this jury, because I want to explore those protocols, can you tell this jury, where did those protocols come from? The AFR and Falk Rocky Mountain protocols.
Okay, so every EMS agency has to have protocols for their paramedics and EMTs to operate under. The Denver Metro agencies, which is basically all the EMS agencies around the Denver Metro area, all kind of work collaboratively. Their physician medical directors have a group which has been meeting, I think, since the 1980s. They developed a group of protocols called the Denver Metro EMS protocols. So this is a collaboration with probably 26 physicians working on a set of protocols. So we have a combined approach for what is correct. And I think that's done for primarily for consistency and because it really, by having 26 physicians all kind of working together to make those protocols, that represents really the standard of care for your area because everyone has the same approach and standard of care is a regional approach.
Okay. Now, you mentioned this Denver Metro EMS Medical Directors Group now twice. Are you a member of that group? Do you participate in that group?
Yes, I do.
Okay. And so I think you spoke to the Denver Metro EMS protocols. Are those protocols separate and apart from the AFR and Falk Rocky Mountain protocols?
Yeah, they're separate documents. Every agency that can either choose to adopt a protocol set in whole, as their medical director can adopt that protocol set, or they can adopt it and adjust it for their department in some ways. So, and generally speaking, we try to have almost universal agreement. Sometimes you might have a particular protocol or a particular program in your city that you put into your protocols for your medics to follow that might be different than what the agency next to you has available. So there might be differences there.
And in this instance, for AFR and Falk Rocky Mountain, Did you, as their medical director, make adjustments to the Denver metro area protocols in implementing the protocols for AFR and FALT?
Yes, the protocols are, Denver Metro updates them every 6 months, and then I update them usually the same month or the month after the Denver Metro set comes out. We make our adjustments as well.
Okay. Cole, can we pull up Defense Exhibit A, please, which is Bates, for the record, Bates S15205. Dr. Hill, do you recognize this document it's been admitted as Defense Exhibit A, and the heading is 0010 General Guidelines Introduction. Do you see that?
Yes, I do.
Cole, can you just scroll down for the doctor to see the entire page? Do you recognize this as being part of the AFR Falk Rocky Mountain Protocol set?
From 2019, yes.
Okay. We can go back to the top, Cole. So in the introduction here, I see that it's written that these protocols are based on the Denver Metro EMS protocols developed by the Denver Metro EMS Directors Group. Is that what you were just speaking to, Doctor?
Yes, it was.
Okay. And what is the purpose of these protocols?
The Aurora Fire specific protocols?
Correct.
They are the standing orders, guidelines, format that tell the paramedics and EMTs for the Aurora EMS system how to work in their environment, how to treat patients.
Okay. And is it specific to the city of Aurora?
Yes. Well, the Aurora EMS protocols are specific to the city of Aurora. Yes.
Okay. And I see here this last sentence here. It says these protocols define the standard of care for EMS providers in the city of Aurora. What does that mean?
So the standard, like I say, the standard of care is a term we use in medicine for what is someone supposed to do with, similar training within that area of how to treat that particular condition. So when we have the Denver Metro agencies all kind of having a unified approach to medical protocols, that creates the standard of care, because what you would get on Aurora is what you would get on the west side of the city or back and forth. So that's what I mean by standards of care.
So is what you're saying is that there's the Aurora or the AFR and Falk Rocky Mountain protocols define the standard of care in Aurora, whereas the Denver Metro protocols define the standard of care in the Denver Metro area?
I think that's a fair assessment. I use them basically synonymously because the protocols are not very different in any way. And if you were to, the way we design them is that some paramedics and EMTs work for multiple agencies. So the concept would be is if I was working in one agency just south, and then I was doing overtime in another agency or part-time somewhere else, that there would not be a significant difference in what they were expected to do on a given call.
Okay. If we come down and jump down to the third paragraph, the first sentence of the third paragraph here, it says that these protocols are presented in an algorithm format. What does that mean?
So some protocols are just listed like a few paragraphs, but those are kind of hard to read and digest. So a lot of the protocols are designed of more of like a stepwise approach. They'll kind of list things like in an algorithm like this and then this. So there's like boxes and arrows, and to kind of navigate someone to say, if this is present, go here. If this is present, not go here. So that's what I mean by algorithm.
Okay. Now, with respect to these protocols as they're being implemented by either EMTs or paramedics, are they designed to be rigidly adhered to, as in step 1, step 2, step 3 that you just described?
No.
Okay. Why not?
Because there's no way to apply a protocol in that way to every given scenario they may have. Every protocol has to be applied to the situation that you're on, and every situation is different. So if you have a patient who, based on your experience and training, is it kind of this part of the protocol? I mean, meaning they're further down, or you need to be more aggressive in your action. then that's where you should operate within. So we don't follow like a regimented format. And I think we actually say that it's not expected to be regimented that way.
Okay. And when you say you think you say that, is that essentially what you've stated here in the last sentence of the third paragraph, where it says an algorithm provides decision-making support but need not be rigidly adhered to and is no substitute for sound clinical judgment?
That is correct.
Okay. I want to, Cole, if you can just scroll down a little bit further. This protocol key, we've got two boxes here. One says EMT. You don't need to highlight, it's fine. One says EMT and it's a white box, and one says paramedic and it's kind of shaded or has the backfill of the blue. What does that mean?
It's meant to be a easy reference guide for the providers that are working. In Aurora, we only really have EMTs and paramedics. There are a couple other certification levels that we don't operate with. So we just have EMTs and paramedics. So if it's a medication or a procedure or something in the protocol that's really restricted to the paramedic level, then it would have a background of blue. And if it was white or having no color to it, essentially it would be okay for paramedics or EMTs to do it.
Okay. And then there's this gray box that says teaching points. What does that mean?
So teaching points they're basically helpful information, not necessarily part of a normal like algorithmic flow of a call, but there may be just interesting or helpful informational points that you would point to on a given protocol that the medical directors wanted the paramedics to have available if they had questions.
Okay. Cole, can we bring up People's Exhibit 219? So when we look at People's Exhibit 219, this is the protocol 6010, the agitated combative patient protocol. Do you recognize that, Doctor?
I do.
Okay. So again, here we've kind of got that block from that protocol key with the EMT and the paramedic here. Do you see that?
Yes.
Okay. So Cole, can you zoom out and show the whole page for me again? So we see various boxes here that are shaded. So when we see this shaded box in blue or this one, is that meant to mean that that's direction and guidance to a paramedic as opposed to an EMT?
Correct.
Okay. And the boxes that are white, is that instructions to just EMTs or is that instruction to both EMTs and paramedics?
Both of them.
Okay. And then we see the gray areas here with the general guideline, the restraints, and the consider the cause of agitation. Those are those teaching points, gray area. Is that right?
That is correct.
Okay. You talked about whether or not these protocols need to be rigidly adhered to. So if you had a protocol such as this one that had several boxes with the arrow, would it be possible for a paramedic or an EMT to be considering multiple boxes simultaneously?
Objection, cause for speculation.
Let me rephrase.
All right.
In writing these protocols as the medical director, was it your intent for paramedics and EMTs to be able to consider multiple boxes simultaneously?
Yes.
Why?
Because as I said, one is there's often multiple things going on at the same time in any given patient. Two is there might be multiple people there. So one person might be working on one thing and someone else is working on another, but that doesn't mean that you have to complete one before you go to the next. So it's every situation is different as to how you approach the protocols.
Would there be certain situations where it might make sense to consider one box at a time and go in that order?
Sure.
You can take that down, Cole. Thank you. We've talked a little bit, and I may come back to 219, that agitated combative patient protocol here in a few minutes, but I want to kind of shift gears for you a little bit and talk still about the protocols. But in 2019, was there a protocol for EMTs and paramedics that directed them when they could take control of a patient on any particular scene? Was there a specific protocol that spoke to that?
Particular protocol about when they can take control of a patient?
Correct.
No.
Okay. So for example, if paramedics arrive on a scene where there's multiple agencies, perhaps say law enforcement, Aurora PD, and AFR, and Aurora PD is engaged with a patient in restraining them, was there a protocol indicating kind of the handoff of that patient or the transition of that patient from APD custody to AFR custody?
No, there is no protocol that defines the interaction between law enforcement and paramedics.
Okay. Are there protocols that indicate whether or not, so AFR arrives on a scene. Is there a protocol in which they're required to make a determination about whether or not the person they're encountering is a patient as opposed to not being a patient?
Yes, there is.
Okay, can you explain that to the jury? What kind of assessment or decision making under those protocols must a paramedic or an EMT at AFR engage in?
Sure. So I think there's actually, it's called the patient, no patient protocol. And what you're trying to explain is when you arrive on a scene, you're called to something. Sometimes you might get called to something and there really is not a medical condition. Someone assumed something and they did not, you found that was not really a medical issue that required anything. And so in that case, you might consider that to be a no patient contact. And in a no patient contact, you would not do a patient assessment in a patient care report. I'm sorry, I'll try to avoid acronyms. And then but sometimes you might say there is a patient. And so that could be either by, what the patient is telling you is going on, such as, they have a particular complaint of injury or illness, something that you obtain from either your assessment or a third party that might tell you this is a patient. And in that situation, you would say, this is my patient, and you would operate, treating them as a patient.
Is it possible to decide that someone is your patient and treat that patient without having actual custody or physical control of that patient?
That's like you're not in physical custody. I guess
Correct. So for example, the example I gave you just a moment ago, when a patient is being physically restrained by Aurora PD, is it possible to consider that person your patient, treat them, but not have physical custody of them?
Objection, speculative and outside the scope of the endorsement.
Well, I'm asking I don't think it's speculative. I'm asking if that's to his knowledge and he wrote the protocols.
Oh, all right, I will allow counsel to rephrase the question, please.
Okay, I can do my best. Thank you, Your Honor. Under the protocols, are there certain situations where paramedics and EMTs may consider a subject their patient, but not have physical custody of that person yet?
Objection, vague.
I'm assuming this is going somewhere else. I'll allow it.
Thank you, Your Honor.
I would say yes.
Okay. I want to talk a little bit about Cole, can we put up 219 again, please? Okay. So, Doctor, I want to direct your attention to the portion of the agitated combative patient protocol that talks about, in this blue box, that talks about give ketamine, okay? So I want to talk about ketamine and how it became a part of this protocol for a few minutes. You can go ahead and take that down, Cole. We've seen, and there's been testimony about ketamine being the treatment that is supposed to be given when you suspect somebody is suffering from excited delirium syndrome in 2019. In AFR, in Falk, had that always been the case? Was ketamine the drug of choice for excited delirium?
No.
When did it become, under the protocols, the prescribed treatment for excited delirium?
It'd be a rough date, so I believe the protocol for that went in effect sometime around early fall, maybe October-ish of 2018.
Okay. And was there a process that you as the medical director had to go through with the state in order to get authorization for ketamine to be used in that manner?
Yes.
What process, can you tell the jury and educate the jury, what process did you have to go through to accomplish that? Okay.
So Colorado, the paramedics and EMTs of Colorado operate under they're licensed or certified, credentialed by the state of Colorado under a certain branch of the Public Health Environment Department. They have a document, we refer to as Chapter 2 guidelines, but really it defines kind of what a paramedic is, what an EMT is, what a medical director is. It also defines very clearly in there the acts allowed, which is specifically what acts the state's already predetermined are okay to be listed within their protocols. So it lists the medications and the interventions specific to what kind of, whether they're a paramedic or EMT. So they break them out in that document. That's what we call it's a ceiling. And what I mean by that is that a medical director can pick and choose from within there what they have in their protocols for their agency. But anything that's not listed there, no matter how benign, no matter what it is, has to go through a waiver process. So the way the state way this was operating in 2019 is that a medical director would initiate a waiver, request the particular intervention, medication, whatever it is they want to have approved. That would go to a advisory board from the state of Colorado, and it's called the Emergency Medicine Practice Advisory Council. They review the waiver, and then they would give a recommendation to the department about approval or not approval. And then the department issues the approval, department meaning the Colorado Department of Public Health and Environment. They issue the approval for the waiver to be used by that agency with the medical director.
Okay. So in 2018, was ketamine a new drug?
No.
Okay. Was it new to being used by paramedics in their paramedic roles?
It was, I'm aware of waivers and agencies using it more extensively around the 2010, 2009 timeframe. So at that time, it was not in Chapter 2 guidelines at that point. So the department was issuing waivers, and they typically do that for many years with any kind of new medication or procedure.
Okay. And so to be clear, using ketamine to treat excited delirium for AFR and for Falk would have been a new procedure or a new use for a drug that had been around for a while. Is that?
Yes, for that agency, it was new for that. It was new for Aurora Fire and Falk.
Okay. And so I'm assuming then, because it's in the protocol, that in 2018, your waiver application was approved by the state for use of ketamine for that purpose.
That is correct.
Okay. I want to talk now a little bit about ketamine. Prior to obtaining the waiver in 2018 to use ketamine to treat excited delirium, how was AFR and Falk treating excited delirium?
They were using a high dose of midazolam.
Okay, and I think we've heard midazolam, the generic label for that is Versed?
Correct.
Okay. Why did you elect to make the decision to move from Versed towards ketamine?
I think, well, there's a couple different reasons for it. Midazolam has certain chemical properties to it. Every medication has certain properties that we look for as far as the benefits or side effects. Versed or midazolam has a certain onset of action, which was fairly long. It can be up to 10 to 15 minutes to have full effect because it doesn't cross the blood-brain barrier very well to cause the effects we're looking for. It also had a lot of side effects with it. At the time in 2017 and early 2018, we were seeing a lot of cases of severely agitated combative patients that were refractory to midazolam, refractory meaning that it was not working for them. These patients were coming in to the emergency departments completely out of control, and they were using ketamine in the emergency departments to control those individuals. So that was the primary impetus for me to look for another option at that time for the department.
Okay. Other than its fast-acting nature or its quick onset, were there other properties with respect to ketamine that made it a more favorable drug to use in these circumstances?
Yes.
What were those?
So this gets into how ketamine works. Ketamine is like a dissociative anesthetic. It's not what I would call it's a dissociative anesthetic. And so the way that's going to work is it's almost like a disconnect between the upper level brain and your more reptilian brain, which is the way that the brain stem. So the way it works is that basically the lights are on, but nobody's home. So the core brain functions of the brain stem, which is basically, pulse, respirations, those things are maintained versus the perception of pain, cognitive function is suppressed.
Okay. And so compared to, say, Versed or other sedatives, how is ketamine with respect, and if you can explain this to the jury, how is ketamine with respect to, we've heard reference to a safety profile. Do you know what that means?
Yes.
What is that? Can you tell the jury what that means, that terminology to you, the safety profile?
So when we're referring to a safety profile, we're really referring to the different biochemical properties of a medication that make it okay to use in particular situations. And that can be, what the side effects are. It could be things of the dosing range as far as, is it a really narrow window or a wide window, meaning that there's room for error in there. It can be, the effects on the body, meaning that there's, or numerous, beneficial or safer properties relating to the hemodynamics of your patient, as opposed to other medications. So if I was to compare it to a narrow profile versus a wide profile, narrow profile is very regimented. You have to be very accurate, and wide is much more forgiving for inaccuracies.
Okay. And when you talk about inaccuracies, what type of inaccuracies are you speaking about?
The dosing.
Okay. So help the jury understand, what do you mean by wide inaccuracies in dosing? What is meant by that?
Well, the dosing listed for any given medication, they typically have a listed dose of what they say the range of something is allowed to use. Ketamine has a wide dosing regimen, anywhere from 3 to 4 to 5, maybe 6 milligrams per kilogram is listed. There's also, what that means is if you were to give 4 or 5 or 6 or anywhere in that number, you're going to have an appropriate response without having the deleterious response. Okay.
And doctor, I'm going to stop you. When you say deleterious response, what do you mean? Tell the jury what you mean by that.
And I guess deleterious, adverse or serious complication.
Okay, and I interrupted you, so please continue. I think you were talking about the wide safety profile with respect to dosing.
Sure. So along with that, we also look at, what is the risks if you give too little or too much of a medication. There are some medications that you have to be very, very precise like in a hospital setting with a scale, because the therapeutic window is very small and too much can cause serious harm to a patient, and some too little may not be effective or enough. Example of that might be the medications we give for a stroke. We give the medication called a thrombolytic, which dissolves clots. You have to be very specific about that because too little and it won't dissolve the clot, and too much and you can cause bleeding in the brain. If it's wide, it means that whether I, got the dose I was getting for, or I gave too much, it's not anticipated there'd be any serious risks to the patient for that dose. So that's what I mean by wide.
Are there any published studies or literature that you looked at when you were making that decision for the waiver with respect to kind of this forgiveness in the dosing that convinced you that ketamine was an appropriate choice?
Yes.
Object to getting outside the scope of the expert's endorsement.
Response?
I believe the question was whether or not he considered that as part of the waiver process. And so I don't think it's outside the scope of either the endorsement or his prior testimony.
All right, I'll let him get into it generally.
Okay. So generally speaking, what does the literature say about this wide margin with respect to dosing and effects that wide margin of dosing may have on a patient?
So the majority of the literature that we reviewed, it's primarily published especially in the last 10 years, mostly in the emergency medicine literature. It basically says that for the side effects, okay, let me take this back. So the dosing range is in that 4 to 5 mg per kg commonly. Sometimes it's as high as 6, I've seen it. It also lists, there are some comparison studies that they reference in the articles as well, saying, okay, what if someone gets too much of a medication? And so one was a meta-analysis that I reviewed. It showed that whether it was 5 mg per kg or 7 mg per kg, that the serious complications between those two doses were no difference.
Okay. And so you just talked about complications. And so we were talking about a wide safety profile for dosing. Does ketamine also have a wide safety profile with respect to side effects?
I mean, there are side effects. I'm not sure how I'd classify a wide safety profile for side effects. There are side effects of ketamine, but could you be more specific for me?
Sure. Well, help tell the jury what are some of the known side effects of ketamine?
So hypersalivation increases production of saliva from your saliva glands. Rare cases, that's not very common, but it can happen. There's something called laryngospasm, which is where the vocal cords spasm. That's also very rare. Vomiting has been described. Typically, it's later in the course of the ketamine, but it has been described in the literature. I think here are the rest of them. There's something called an emergence reaction, which is when someone's coming out of ketamine, it's very disorienting. So as the brain's kind of waking back up, the patient might have a sense of panic or sense of kind of dysphoria, not feeling good related to the ketamine administration. So that's not uncommon as well to see.
We've heard some testimony, but I did not hear you speak to this concept of respiratory depression. Are you familiar with that concept?
Yes.
Okay. And I noticed that that wasn't in your list of side effects. Can you speak to, based on your research and your consideration for ketamine for the waiver, what do we know about ketamine's impact or effect on one's respiratory system or respiratory depression?
So in my experience and what I've reviewed, the risks of respiratory depression are primarily around the rapid intravenous administration of the drug. Sometimes also very young patients. With intramuscular dosing, which is what we were using, that is not considered to be a listed common occurrence to occur or known side effect.
Okay. And so, when you say intramuscular as we were using, does the AFR protocols, when it calls for the administration of ketamine, how does it call for ketamine to be delivered?
It's delivered intramuscularly.
And just explain to the jury what that means.
So different routes of medication administration. Intramuscular is specific to giving an injection into a muscle and letting the body absorb it from the muscle.
Doctor, I want to shift gears on you a little bit. We're still kind of staying tethered to that agitated combative patient protocol, but I want to shift subjects on you. Can you explain to the jury and tell the jury what is excited delirium?
So excited delirium it's basically a syndrome to describe a patient who is in a hyper manic, agitated, combative state. So I break it down to the two words, excited and delirium. Delirium, you could essentially think of it as like altered mental status or not able to converse. Something's not, so it seems something's off about the individual. Excited is really referring to the physiology related to that. So if you think about excited physiology would be sympathomimetic, which is like your adrenaline system. So it's a combination of symptoms showing someone to be under a sympathetic nervous system response, as well as altered mental status.
You used a term there that I don't think I've ever heard before.
Sympathetic. So you have, it's part of your sympathetic nervous system as part of your autonomic nervous system. You've got two parts to that. You've got a parasympathetic, which slows you down, and you've got a sympathetic, which speeds you up. So if you were sympathetic, the primarily biochemical marker we use is adrenaline. So if you are, if you think about if you're doing a fight or flight type response, or you're running or something along those lines, your body releases adrenaline into your body. And the adrenaline is your sympathetic nervous system ramping up your body, and it's preparing your body for whatever it needs to do.
Okay. Now you talked about the excited portion of excited delirium as being manic state or aggressive or combative. Are there certain signs or symptoms that AFR and Falk paramedics are trained to look for in determining and assessing whether or not someone is acting consistent with excited delirium?
Yes, of the protocol, there is a list of kind of known signs or symptoms. Those are slightly different things, but they are basically what someone might be able to recognize as someone who could have that condition that's listed in the protocol.
And what are those signs and symptoms?
I'll try to make sure I give you a comprehensive list. So a physical sign could be something along the lines of tachycardia, which is fast heart rate, breathing fast, or tachypnea, diaphoresis. You might see.
What does diaphoresis mean?
Sorry, sweating,
Okay.
being sweaty. They can be hot to the touch or hyperthermic. You may also see things or be told things along the lines of, these are more like symptoms of hyperaggression, increased strength, paranoia, confusion. Those are things that are harder to see, but they might be a symptom that you might interpret.
You talked about hyperthermia. Is skin that's cold or clammy, can that also be consistent with a sign or symptom of excited delirium?
It would not be a common occurrence. I mean, you do have to be someone that was, I think, very ill at that point, but that's not a common occurrence to say that someone would be cold.
So cold and clammy might be a sign of something else, not necessarily excited delirium. Is that what I'm hearing you say?
I mean, when I think of cold and clammy, we typically think more like a shock state, or there's some sort of a serious metabolic problem going on. So if someone's clammy that way.
Okay. You said something there about metabolic. So I want to talk about still staying on the topic of excited delirium. So when you have a patient that is suffering from excited delirium or in an excited delirium state, what is happening to them medically?
So there's a lot of things medically, and it's fairly complex stuff. But I think, so one is just the adrenaline in your body causing your body to ramp up. So all the physical effects you would normally expect to see, if you're in a sympathetic, have a lot of adrenaline dumping in your body, you might feel panic, you might feel heart rate increase, diaphoresis, that sweating, sorry, medical terms, I'm sorry,
Okay.
breathing fast. You're also, your body is trying to compensate for a lot of different things going on there. And so one of the things we see with the respiratory rate being increased is not just because of the adrenaline, it's often because they're trying to compensate for an acidosis in their body. So if you were to imagine going running, like you did a 800-meter sprint, and at the end you're puffing and puffing and trying to really catch your breath, we call it catching your breath, that's not actually because your oxygen levels are low in your body at that point. That's because you've developed a ton of lactic acid as a result of what you just did. And the body does not like to be acidic. The body likes a very narrow pH of 7.4. So one of the compensatory mechanisms the body has in order to get rid of that acid and get back to where you're supposed to be is it breathes fast. It breathes fast and breathes deep.
Can acidosis be a metabolic problem for a patient?
Sure, and it can be a combination of respiratory and metabolic, but metabolic acidosis actually includes lactic acidosis.
Okay. Is there any kind of test that you can give someone to know or to confirm whether or not they're actually suffering from or experiencing excited delirium?
No, there's no confirmatory test. Think of it more as like a syndrome of something you're looking for, but there's not a diagnostic test that I can point to say this is there or not there.
Okay. And on the range of medical conditions from not very serious to serious, where would you plot excited delirium on that scale?
Very serious.
Can you explain that to the jury? Why is it serious?
The reason why this, I guess, terminology came around and the way we approach it is the emergency physicians were seeing a lot of these kind of cases in the 90s and early 2000s, and there was a white paper published in 2009, and it's by the American College of Emergency Physicians that really defined this kind of syndrome. And what it recognizes is that if untreated, okay, if someone has excited delirium and they continue to be in that state or they continue to fight in that state, that they are at an increased risk of death. And so the thought was, okay, we have to recognize this for what it is, and it's a medical emergency. So there was protocols developed and trainings developed along those lines to say, we need to train paramedics, we need to train police officers to recognize this, to not just assume someone's being combative and to treat it medically. And then with the overall impetus is to save lives.
Okay. And if Cole, if we could put up 219 again, People's 219. So doctor, is that what you mean by when you write in the protocol that the goal here is for rapid, you use the word tranquilization, I believe, rapid tranquilization in order to minimize time struggling. Is that what you're referring to?
Yes.
Okay, you can go ahead and pull that down, Cole. So you talked about the danger of allowing excited delirium to go untreated. So in Aurora, how do you all treat, particularly in 2019, how did you treat excited delirium or somebody who was acting consistent with the symptoms of excited delirium?
Are you referring to a specific medication?
Yes.
The approved medication for excited delirium was ketamine.
Okay. Now, why would you want to give somebody ketamine in that state?
I think well, like I say, that gets into the reasons for how the medication works and the benefits of it. One is we don't want them to continue to fight with law enforcement. We think that increases their risk of serious bodily injury or death. So the time of onset of the medication is very good for that because it's usually within a few minutes. There's also significant benefits to their blood pressure as well as respiratory status, which is why we prefer that medication. The alternatives that we had much worse side effect profiles.
Okay. So with respect to, I lost my question here. Give me 1 second. Sorry. Now, in your research about ketamine and as part of the waiver process, were there any contraindications? And what I mean by contraindications, was there any research or information about when ketamine should not be administered?
If the indications for the medication are there, the contraindications are very small. The only one we really list, there was two that I was primarily aware of. One was a penetrating eye injury, because ketamine could potentially increase your intraocular pressure, which would cause some of your eye contents to extrude. And then there was also one that was discussed around the idea of increased intracranial pressure for a head injury, but that's been kind of, I think, debunked in medical literature. That was more of a, I think, a historical concern.
We talked a little bit about lactic acidosis and metabolic acidosis as a result of excited delirium. Is acidosis a contraindication for giving ketamine?
No.
Would hypoxia be a contraindication for giving ketamine?
No.
What about if you had concerns if your patient had aspirated? Would aspiration be a contraindication for ketamine?
Not for the reasons we're using it for. Okay. I want to draw a delineation between utilizing it in a field environment for this purpose and like a hospital setting, which is like for like a procedural sedation. Like that's a totally different reason. But
and doctor, I want to narrow your focus just to the protocols. So under the protocols, so administering it under the conditions that are defined in the protocol, so which would be that field setting you're talking about. Was aspiration a contraindication for administering ketamine in that circumstance? I want to talk to you, shifting gears now, I want to talk to you a little bit about decision-making capacity with respect to a patient, okay?
okay.
Is there a protocol in AFR that talks about consent and decision-making capacity of a patient?
There is.
Okay. Now, I want to be clear here, doctor. When in talking about this, my questions, consent is both a legal term and a medical term. Is that fair?
I think it'd be fair.
Okay. My questions to you are only geared towards the medical term of consent or decision making. Okay. So I want to be clear. So there's no interpretation of my questions to you.
I understand.
Okay. So when you go through that protocol that you were talking about earlier about patient, no patient, is one of the things you're training the paramedics and EMTs to do through that analysis is deciding whether or not somebody has decision-making capacity?
There is a determination, yes.
Okay. When you have a patient who, and we'll just stick under the agitated and combative patient protocol in excited delirium. When you have a patient that is that you view as maybe suffering from excited delirium or acting consistent with the signs and symptoms of excited delirium, are the paramedics and EMTs trained as to whether or not that individual would be considered under the medical standard of having decision-making capability or capacity?
Objection, Your Honor. I think this is a 401 and 403 problem and is likely to lead to confusion.
All right. Based upon the court's earlier discussions with counsel, the court will overrule the objection as to the medical training or protocols.
Okay, so if you think someone has excited delirium, the ultramental status would preclude them from being able to be able to make an informed decision and have consent.
Okay. So from a medical perspective, are you then precluded from treating them?
No.
Why not?
Because if you think someone's in distress and they have a medical emergency to interpret, there's a concept that we call implied consent, which means that someone who we think would be a reasonable person would want medical care in that situation. So we tell them to treat the patient under implied consent.
And when you say we, are you referring to the medical field and particularly AFR and Falk?
It's not particular to AFR and Falk. I mean, implied consent is, I've heard that for 30 years of doing this.
As a medical term
Yes, it's a medical term.
and a medical concept.
It's a medical concept, yes.
Okay. Cole, can we bring up 219 again, please? Okay. Doctor, I now want to draw your attention to this portion of the protocol 6010, the agitated combative patient protocol. And I particularly want to talk about the protocol as it relates to these boxes immediately following the give ketamine box, okay?
Okay.
And Cole, maybe if we could blow that up a little bit for everybody to see. Okay. We have a box here that's in white that says complete the restraint protocol. What does that mean, doctor?
There's a separate protocol that just defines restraints on a patient. And so it's referring to the application of what they call soft restraints.
Okay. So let's talk about that restraint protocol a little bit here. That protocol, is that restraint protocol just specific to this agitated combative patient protocol and situation, or is it broader than that?
I'd have to see where it's referenced in the protocols. We typically hyperlink something, but it's more general, I would say.
Okay. And so why don't we Cole, can we pull up People's Exhibit 208? Doctor, People's Exhibit 208, it's been admitted. This is entitled 1130 Procedure Protocol, Restraint Protocol. Is this that restraint protocol that is referenced and hyperlinked in the agitated and combative patient protocol?
Yes, it is.
Okay. Now, this looks like a pretty detailed and lengthy protocol. Is this protocol designed specifically, and I see at the bottom here, there's also a reference to excited delirium. Is this protocol written just for the excited delirium circumstances and situation?
No, it's used much more commonly than that.
Okay. And so when you make reference in the agitated combative patient protocol to complete the restraint protocol, was it your intent to have EMTs and paramedics rigidly start from the top and go all the way to the bottom?
No.
Why not?
Because I guess two reasons. One is if you have someone that you think has excited delirium and you're trying to move, onto your next treatment, you wouldn't start all the way to the top. Typically, restraints are just as simple as that. You're applying a soft restraint to the extremities and buckling them to the pram, and then that's the basic process of restraint.
Okay. Cole, can we zoom in on the top part of that, the indications A, B? Yes, thank you. So, for example, sorry, I lost. So, for example, this under A here, where it talks about try alternative methods first. Example, verbal de-escalation should be used first if the situation allows. In linking the restraint protocol to the agitated combative patient protocol, were you instructing or expecting EMTs and paramedics to try and verbally de-escalate somebody with excited delirium?
No.
Why not?
Well, one, where this protocol is at is, or where this is referenced is after you've already given a sedative medication. So there is no, you need to move on in your protocol and do the other steps. You're not de-escalating anything at that point.
Okay, so the intent of referring to the restraint protocol was to go to the point of the restraint protocol that talked about how to apply the soft restraints?
Yes.
Okay, so would it be appropriate to expect a paramedic or an EMT who was coming over to this protocol from the agitated combative protocol, would it be inappropriate for them to ignore or skip this portion of the protocol and just go to the soft restraint portion?
No.
Objection, speculation.
Okay.
Response?
I think I can rephrase that. Was it your intent
I'll allow you to rephrase. So
Okay.
Sustained in part.
in hyperlinking the restraint protocol to the agitative combative patient protocol? Was it your intent for, at that stage of the protocol, for paramedics and EMTs to employ the soft restraint portion of this protocol?
Objection, leading.
Overruled objection.
So my intent was to have them apply the soft restraints.
Okay, we can go ahead and take this down, Cole. Thank you. Cole, can we put up 219 again, please? Okay, and again, I want to focus again down this right column here, Doctor. Now below the complete the restraint protocol to the next, you can just highlight that all, Cole, that's fine. So here we have this next box that talks about reassess ABCs, and it has some different steps here. What's the purpose of this box in this protocol, Doctor?
It's just to outline the kind of next steps of intervention as you start further treatment of your patient.
And when you say next steps, is this to be done after sedation is accomplished?
Yes.
Okay. And when you say reassess ABCs, what are you referencing there?
It's just your airway, breathing, circulation. So to make sure that they have an airway, that they're still breathing. And by definition, if they're breathing, they have a pulse.
Okay. And so, and you say by definition, so is it possible to reassess those ABCs visually?
Yes.
Okay. And then it talks about cardiac SpO2, which I think is pulse oximetry. Is that what SpO2 means?
SpO2 is pulse oximetry.
Okay. So it talks about some of these other, what looks to be like monitoring that needs to occur post sedation. Am I reading that right?
Yes, those are the monitors that we ask them to apply post sedation.
So either in this protocol, and Cole, maybe let's back out to the entire protocol. So either in the boxes or the teaching points, the gray shaded areas, does this protocol instruct EMTs and paramedics when this monitoring needs to be applied to the patient?
Other than just in the post sedation period, it does not define that.
Okay. But it should be done post sedation. Is that what you just testified to?
Yes, I don't think you could effectively apply those kind of monitoring before they're sedated.
Okay. And so after sedation, after the 4-point restraints, then we get into the monitoring phase on
Yes.
on the protocol? Okay.
Yes.
And is it your expectation that that monitoring would be ongoing through transport to the hospital?
Correct.
This monitoring equipment that is referenced in this protocol, is that monitoring equipment located on Aurora Fire apparatus?
Yes, they have those pieces of equipment.
Okay. Is it also located on the Falk ambulance apparatus?
It is.
Does the protocol indicate a preference as to which apparatuses equipment be used to monitor the patient?
It does not.
Okay. In 2019, was there a protocol that instructed EMTs and paramedics about what specific equipment needed to be brought to a particular type of call?
No, I cannot think of a protocol that says that that defines what equipment to bring on a particular call.
Okay. How then would a paramedic or an EMT know what equipment to bring to a call if there was no protocol?
Sometimes from their education, training, background, experience, based on what they're told they're going on, they may know that they need to bring something. Sometimes it's after they get on scene and they evaluate the patient, they determine they need a piece of equipment to be used. I think it varies.
So you said that they were, if they're told by the nature of call, so would you expect them to process information that they obtained during dispatch, or the nature of the call that they were being dispatched to? That might inform what equipment they would bring?
Sure, absolutely.
Okay. Or I think I heard you say once they arrived on scene and made an assessment of the situation?
Yeah, I think that there are times that you have to factor in where your patient is and what the situation is. There are times that you have everything because you're going to be going up in a building or something and you bring everything that you think you might need. There are times that you don't do that. So it depends on your situation. If you find you need something that you don't have, you need to go get it.
And you just testified there that if you find you need something that you don't have, so would that decision be based upon need, either the paramedic's need or say the patient's need?
Yes.
Now you testified a little bit about that ketamine has a wide dose safety profile, but that it is a weight-based medication, right?
That is correct.
Okay. In the training and I'm talking specifically 2018 and 2019, the training for Aurora Fire Rescue and Falk paramedics, was there any specific training provided to them about how one would go about determining weight in the field of a patient?
No, there's nothing taught in any kind of trainings or education about how to determine someone's weight.
Do the Falk ambulance, the gurneys on the ambulance, are they weighted gurneys? Do they have scales on them?
They do not have that capability now.
Okay. So how then are EMTs and paramedics, how are they supposed to determine the weight of a patient when they need to give a weight-based medication?
So it depends on the nature of the person. For pediatric, they have a tool. It's called a Braslow tape, and it's a length-based tape that they use. That kind of thing does not exist for an adult. So it's kind of their best estimate.
Okay. So something they just have to eyeball visually.
Yeah, I can't think of a better way to describe it than, I think everyone probably does it a little bit differently how they do it. And so it's not defined in any training or protocol or education plan about how you do that.
Okay. We talked about that these protocols define the standard of care for EMS professionals in Aurora. Is there a difference between a standard of care in Aurora between a hospital setting and a field setting?
Objection calls for a legal conclusion.
I'm not asking legally, so medically, talking about a medical standard of care, Judge. That's what and I can.
If that's clear.
I'm happy to clarify my question in that regard. So doctor, with respect to, you testified earlier that these protocols establish the medical standard of care. Did I hear that right?
That's correct.
Okay. So from a medical perspective, are there different standards of care for a hospital setting versus a field setting?
Yes.
Okay. Are there different standards of care for, say, doctors as opposed to paramedics?
Yes, doctors are not compared to paramedics.
Are paramedics compared to doctors?
No.
Why not?
I think that's their education, training, and experience levels make them not the same ability to interpret what's going on, make a decision plan. So that in that regards, you cannot have a paramedic held to what a physician would interpret as something. That's the reason why.
Okay. If I may have a moment, Your Honor.
Yes.
Doctor, I really appreciate your time and information this afternoon. I don't have any further questions for you at this point. Thank you.
Thank you.
On behalf of Mr. Cooper? Me? Okay. Why don't we try to take a short one, and we'll just have the jurors go back into the jury room for a few moments and maybe get a drink or something, and we'll try to be back in roughly 10 minutes or so. So don't form or express any opinions or deliberate or discuss the case. Avoid research and the press. Jurors have stepped out. Folks can be seated, and you may step down if you'd like to. If you could be back in about 10 minutes, please. Now see if you'd like. All right.
No, so let me, I mean, it's just, hey, let me grab this. Here's what it is. That's all.
Oh.
Wi-Fi access. It's so weird. If you go out of the room, it drops.
The jurors have returned. Please be seated. We'll recall 21 CR 2800 and 2806. We're ready to start the examination on behalf of Mr. Cooper.
Thank you, Your Honor. And just so I don't get in trouble, I believe this is cross. So if I'm leading, is that okay?
I'm assuming the witness wasn't endorsed by your client.
Correct.
Okay.
All right. Dr. Hill, I just want to start where we just ended, and then maybe that'll help track going backwards, okay? So when you were talking about medically speaking, the standards of care being different for doctors versus paramedics, and you said that's based on kind of the training. In your training of educators, educating paramedics, about how much education do they get?
All inclusive of paramedic school, including their field rides, it's in the ballpark of 1,600, 1,700
Okay, hours?
hours.
Is that over 6 to 9 month span? Does that sound right?
Depends on the nature of the program, how aggressive it is. Some are as short as 6 to 9 months, some are as long as a year.
Okay,
And
fair enough. How does that compare to what a medical doctor goes through by the time they're board certified? If you could explain.
Sorry, I mean, physicians, so to be board certified, you have to complete medical school, complete your residency training. Residency training can be anywhere from 3 to 5 years, depending upon what specialty you're in. And then you go through a board certification process, which is an additional testing process after your residency trained. The ballpark is probably closer to 17 to 18,000 hours.
Okay. So to be clear, paramedics do not have to have any sort of college degree to become a paramedic.
No, they do not.
But to be a doctor, you need a 4-year college degree, correct?
I believe most schools do require a 4-year college degree, yes.
4-year medical school degree, correct?
Yes.
A 3 to 5 year residency program, correct?
Yes, if you're board certified, you've completed a 3 to 5 year residency program.
Oftentimes a fellowship after that, correct?
Many physicians do fellowships, not everybody, but some do fellowships for 1 to 2 years.
And then your compliance with board certification requirements after that.
Correct.
So I want to talk about, you were talking about the weight-based and trying to figure out, and you said at this time in 2019, when the protocol was unrolled with ketamine, there was not incorporated into the training any training on how to estimate weight. Is that fair to say?
That's true.
In 2019.
True.
In pediatrics, did I hear you say there was a Brazello tape?
So pediatrics, we have it's a length-based tape, and this is something we use in kids. Like mostly, I think it caps out around a few years old. But basically, when you lay them down, it's a length-based tape. So by laying it next to the individual, you can calculate basically roughly what their weight is, because babies and toddlers tend to have a very similar body habitus. So it's a reliable way to interpret someone's weight as a pediatric.
Okay. And that doesn't carry over. Well, before I go there, let me clarify. In 2019, AFR protocols defined pediatric as 12 and under, correct?
Correct. Although Brazello tapes don't go up to 12 years old.
How old do they go up to?
I had to look at the tape to actually tell you how the weight. It's not necessarily an age; it's a weight.
Gotcha.
So I had to look and see how far it goes up, but it's nowhere close to 12.
Okay. But then when we shift to 12 and up, that takes you all the way until somebody's death, whether it's at 125 or at 12. That's the rest of the protocols. Fair to say?
Protocols we consider it for 12 and above. Yes.
Okay. And part of that, with respect to weight, is when you look at somebody, there's a lot of factors that affect what they weigh. Is that fair to say?
Can you repeat the question exactly?
I hate to go here, but like if you were to put 3 people my height right next to each other, would we all be the same weight?
No.
Even if we look to the eyeball the same, is it very realistic we might have very different weights?
Sure.
I'm not going to ask you to guess my weight, but what are the things that kind of factor in? Is it body mass? What are the things that factor in?
So as far as a weight estimation, I think it's a combination of your height and your body mass. We call it body mass index, and that would be kind of give you a general idea. So that'd be probably the best way I would describe it.
Fair enough. Is it fair to say sometimes you have really tall people that are very, very lightweight and very short people that are very heavyweight?
Yes.
And so when people are trying to make weight estimations in the field on the scene, are there things that in paramedic, when you're training paramedics, are there things that might complicate their ability to make an estimation of a weight?
Yes.
Can you tell the jury kind of what some of those field factors are that would impact their ability to make a good estimate of a weight?
I mean, one is, I think it depends on how you as an individual assess weight. A lot of people will compare it to themselves because they roughly know how big they are and what their weight is, and then they try to make a determination of that. So if they can't make an accurate height determination, that could impact it. If they can't determine body habitus, based on whatever factors they have, to be able to see, are they scrawny, or are they thick, or whatever their body mass is, body type, that would impact their ability to have an accurate weight estimation.
Okay, so in 2019, based on the rollout and the lack of training in this area, people were kind of going on their own kind of ways that they had been guesstimating weight. Is that fair to say?
That's fair.
Okay. And in fairness, in 2019, in the field, were there many weight-based drugs?
No, not excluding pediatric dosing of certain medications for adults. This is either the only one or maybe one of two. It wasn't very many.
Is it fair to say this was a miss in the training?
Yeah.
So in 2019, I want to talk about the fact that there wasn't a protocol as to what equipment to bring to the scene. Do you remember that line of questions?
Do.
Okay. So you said if you find you need something you don't have, go get it. And you started to give examples. Is it fair to say every scene you come across in pre-hospital is different?
Yes, it's a very unknown, dynamic situation, and they never know what they're going on.
Is it fair to say in 2019 when dispatch would dispatch, sometimes they might dispatch a medical asthma attack or medical respiratory attack, something to give you more information?
Yes, sorry. There are times that a dispatcher will give you information that leads you to believe what you're going on, such as you're going on a car accident, or you're going on someone with chest pain, or you're going on a cardiac arrest, those natures. Sometimes they just give you an unknown medical or a med check, very generic term.
So when you're saying if you had more information, you know what you need, if you're dispatched to a cardiac arrest, you're going to take the cardiac equipment, right?
Should.
If you're dispatched on a respiratory arrest, asthmatic call, you're going to take your respiratory kit, right?
Yes.
But if you're dispatched on an unknown medical assist, you might assess your scene first.
Objection calls for speculation.
Based on your training and experience. I can reword.
Sustained.
Okay. Based on the training you were putting the paramedics through in 2019, was it reasonable to gather more information if they could before they took all the kits?
Objection lacks foundation and speculation.
Sustained. If we can refer to a particular protocol, that's fine.
So, Dr. Hill, do your protocols spell out every single different kind of case?
I'm sure they do not.
Okay. So was part of the training in explaining the protocols to kind of walk through what the expectation was?
Can you say that again for me, please?
Sure. So when you're explaining protocols as part of the training to walk your paramedics that are being trained on a protocol, what to expect and what to do pursuant to that protocol?
Objection vague and lacks foundation as to what trainings council's talking about.
These are foundational.
All right. And I'll remind folks the qualification was limited to protocols, training, ketamine, and delirium.
Correct. These are, perhaps I need to clarify with the court. I thought it was protocols, comma.
It was protocols and training, including the use of ketamine and excited delirium.
Okay, I'm a little confused, so I will try to narrow it. So with respect to the protocol, with respect to ketamine and to agitated patients in general, was there any training on if you get dispatched on this call, you take this?
No.
Okay. And in fact, in the training in 2019, was it much more broad than that?
Objection, lack of foundation. I don't know what training you're talking about.
Judge, I'm following up on the last question, talking about agitated patient and.
All right. Well, we need to keep it focused on what was in existence then without
Correct.
comparing.
Correct. In 2019, when that that training? I guess the training was actually in 2018, wasn't it?
The training was in 2018, yes.
Okay. So when the waiver was approved and you're rolling it out to AFR, there was a series of trainings, correct?
There was a series of trainings.
Okay. And in those trainings, they were more broad-based to introduce the new drug and tie it to the concerns around excited delirium. Is that fair to say?
That is true.
Okay. And it was a part-day training? Is that right?
It was, I can't remember how many hours it was. It was a couple part training, but there was a couple hours, 2-3 hours.
Okay. And is it fair to say that in that training, while we talked about what we looked at on the slide, there was no discussion about you have to do this immediately after sedation, things of that nature? Like you didn't walk through the protocol and say, you have to connect this at this time.
No, that was not part of the training.
Okay. Is it also fair to say that as part of the training, the focus was to make sure your paramedics knew that this is a life-threatening situation?
Yes, there was definitely language put in there to make them recognize this is a life-threatening emergency.
And was it also a major focus that sedation of the patient and rapid transport to get them to the doctors was critical?
Yes, that's in the protocol and the training.
Because that's what the hope was, to save these patients' lives.
Yes.
So when we tie that with these scene safety, scenes, sorry, not scene safety, but scenes that you come upon, would it make sense that depending on the scene, if you're up in a high rise, you might expect different things versus if you're 15 feet away from a patient?
Objection, vague, calls for speculation.
Response,
I can tighten it up, Judge, if the court likes.
please.
So would it make sense if in the training and in the protocol, pursuant to the protocols, depending on the situation where your paramedics are confronting somebody that would fall under this protocol, okay? Would it make sense that how they respond would differ depending on if they're going up into a high rise or if the patient's 15 feet away from an ambulance?
Same objections and relevance.
Judge, it goes to their training.
That was the exact same question. If you could tighten it up a little.
So, Dr. Hill, according to your training and protocols, was there anything in the training and protocol that said, if the ambulance is 15 feet away, you have to do X, Y, Z?
No.
Was there anything in the training and protocol that says, if you're in an apartment building, you have to do X, Y, and Z?
No.
Would it differ how you might respond depending on those two scenarios?
Yes.
Why?
Because every scene is different. The paramedics, the officers will make an operational decision about what's going on the call and how to best, I guess, bring resolution to the call or provide care for the patient.
In 2019, was there also a protocol called a handcuff patient protocol?
I think that's the name of the protocol. Yes.
And does that have to do with what happens if handcuffs are not taken off a patient?
Yeah, it's intended to, I guess, define some guidelines for the paramedics around when law enforcement has someone handcuffed about how to transport them.
Okay. Because your paramedics in 2019 had no protocol that allowed them to handcuff a patient, right?
There are no protocols for paramedics to place handcuffs.
In fact, they can't place handcuffs, correct?
That's correct. They cannot do that.
They can use soft restraints, right?
They are authorized to use soft restraints.
You talked about in 2019, when you unrolled the protocol, you were looking at it about your intent in developing the protocol was to have soft restraints applied. Remember that line of questioning?
Yes.
Okay. And I think I heard you correctly. That was after sedation, correct?
Yes, you would apply it after they're in a relative state of sedation or sedation.
Why?
Well, I mean, the purpose of using the medication in someone who's agitated and combative is to not fight them. Like you want to stop the exertion, stop the metabolic process that's going on, which is contributing to the acidosis. So if I'm trying to manipulate someone into physical restraints, I'm doing exactly what I don't want to do. So we want to sedate them first and then apply that restraint.
So if I'm understanding correctly, the ketamine treatment was intended to both externally calm the patient down, right?
Yes,
And then internally, the result is they would calm down as well, and that metabolic acidosis won't get worse.
yeah, I think the way I would describe it is you give ketamine based upon your analysis of physical exertion struggle. And by giving, the ketamine is designed to stop that process there, because if you don't stop that process, the acidosis continues to worsen. And, ketamine does not treat acidosis, it treats the underlying condition that's contributing to the acidosis or causing my acidosis.
And fair enough. And that's something I want to make clear to the jury is when we talk about an excited delirium syndrome versus a disease, I don't know that anybody's explained that. Can you explain the difference between those to them?
I think a syndrome is designed to say there's a constellation of symptoms that you would see to help you formulate a plan as to what's going on with somebody. And so sometimes things are not very well defined of how we do this. We certainly have, idea of delirium. We have an idea of agitated patients. This is intended to show people, okay, look for a spectrum of illness or a spectrum of symptoms. And when you recognize that, that's your, working impression, or, I would term it as a working diagnosis, but paramedics don't diagnose. So we call it like a working impression that you're working off of.
So versus a disease, what's a disease?
I mean, a disease is a process of, I'm not going to give the dictionary answer. I think a disease is a illness or condition which is causing some sort of pathology within the patient.
Okay. So when you're working with a syndrome, you have a constellation of symptoms or patterns, processes that you're trying to assess as a paramedic. Is that fair to say?
Yes.
And incidentally, when you have the paramedics being trained on this, are you teaching them to look for one symptom or sign, or walk the jury through what were they encouraged or taught?
So there's not a criteria that says you have every single piece of those symptoms. The intent of it is to say, when you have someone that you're working in, appears to be agitated, combative, you're really looking for, okay, do I have signs and symptoms that match that particular constellation of problems? So, I would refer back to the name of the condition. Do I see excitatory symptoms? Those are the sympathomimetic, tachypnea, diaphoresis, strength issues. And then you have the signs, altered mental status, paranoia, those kind of things would be the determination of delirium or altered mental status.
Okay. And then if you have those in the protocol, you give the ketamine as the treatment. Without the ketamine is the concern the patient might die.
Yes.
Without the ketamine is the concern the patient might suffer serious bodily injuries.
Yes.
When you give the patients the ketamine and then you transport them, is the goal for the doctors then to treat them?
Yeah, I mean, well, paramedics and EMS are trained to start initial treatments, try to stabilize the patient to the best of their ability, and then transport to an appropriate facility. The physicians at the receiving hospital are then responsible to make the diagnosis, start, continue further care that was not already initiated, and resuscitate.
When you talked about contraindications for ketamine and side effects, I want to be clear with the jury. If you went down the left side of that protocol, the agitated patient, and you end at Versed, what are the concerns about Versed?
So my Dazolam or the Versed medication is a benzodiazepine. It works on the GABA receptor of the brain. So the GABA receptor it's a CNS depressant. It depresses your brain, but it does so by several different mechanisms. And one of the big things is it causes respiratory depression. It can cause some hypotension or low blood pressures. Those are probably the main things. We utilize it as a sedative for certain conditions, but sometimes it's just not the one we want.
And you said that part of your thinking in wanting ketamine on the excited delirium side was it has a faster onset.
Yes.
It has a much more, I think I heard the language, more forgiving safety margin.
Yes.
And the side effects from it are much more rare?
Yeah, I'd say the serious side effects that I see with midazolam are much higher than with ketamine.
And when we look at ketamine, when you talk about it, like, for example, a laryngospasm, that's the throat kind of has a spasm. Is that fair to say?
It's the vocal cords spasm.
Okay. Does that usually resolve itself?
It resolves very quickly with just a little bit of supplemental positive pressure to the thing. Typically, you can get the vocal cords to relax again. So it's not considered to be, as long as you recognize and start treatment, it's very simple to do.
So if you put a bag valve mask or oxygen on, that takes care of that.
Yeah, if you put a bag valve mask on somebody and you squeeze, you're positively pressurizing the airway, and thereby you're basically forcing open the vocal cords and allowing that thing to relax.
Okay. I heard you say hypersalivation, but that you said was rare. But if it occurred, suction takes care of that. Is that correct?
Yeah, it's not a super common reaction. I see it more with certain kids, but we can suction it typically, and that's usually all you have to do.
Okay. I heard you say this emergence reaction, and that's my understanding as a non-doctor is that's as you're coming out, you're emerging from the sedation. That's when you see that reaction.
That's fair.
Okay. And then I heard you say vomiting or nausea, but that's more tied to that emergence side. Is that right?
Most times when you see the vomiting related to ketamine, it's typically as they're kind of coming out of it or further in the process. That's what the literature shows.
Okay. And then we talked a little bit, I heard you talking about this respiratory depression, but that's rare.
The respiratory depression, I think, is route dependent.
Mhm.
Okay. We certainly see it.
And back you up, route means?
Route is how you gave it. So if I gave it IV or intravenous, or if I gave it IM or intramuscular, or if I gave it orally, or if I give it intranasally, that's
Gotcha.
what I mean by route.
Okay. And so route dependent, and I heard you say IV was where you saw those?
Yeah, the words described the most common is seeing it in rapid intravenous administration.
So rapid through an IV, if you push the plunger in quickly and a high dose IV, that's where you see those significant, or where you see still rare, but respiratory depression side effects.
Yeah, so if you were the way I can give an intravenous medication, I can either push it over a few seconds, or I can push it over a minute, or I can drip it in over several minutes. So it depends on how you're giving it exactly.
Gotcha.
I've never seen it defined exactly to say that it's this many seconds, but they define it as if you kind of give it too quickly, that's when you see that particular side effect.
And I think I also heard you say that was most common with children, pediatric.
I've seen it more commonly there. Because we're aware of this, we don't see it. I certainly have seen the literature described more in pediatrics. We don't typically try to push that medication rapidly because we're aware of the problem.
Fair enough. So is it usually at least over a minute? Like you do the slower drip, or do you put it in the drip?
If I'm using it as a sedative, ketamine is used very heavily in kids for procedural sedation for procedures. When we're giving it to them, it's typically done by the nursing staff. They've got very defined protocols. It's pretty rare for the doctor to say, give me this syringe and I'll push it for you. So the nurses have very set protocols about how fast they give it. And it's typically like a minute or two that they kind of give it over.
Fair enough. And thank you for clarifying. That's true. Doctors don't usually have to stick the needle. When you talked about the sympathetic nervous system, so you were talking about the excited delirium and its impact on the sympathetic nervous system. And my understanding was that you were saying that triggers, the belief is it triggers kind of high adrenaline response. Is that right?
Well, the sympathetic nervous system is basically what drives that is the release of adrenaline into your system.
Gotcha. And so when you have that adrenaline release, can that also impact kind of that starting of the acidosis?
Yes.
Okay. And that's not something you can see with the naked eye, just looking at somebody necessarily. Is that fair to say?
You can't see acidosis. You could infer it just based upon like respiratory rate or something that you might have a problem, but it's certainly not diagnostic. It'd be more like a clue.
So that you were getting to my next question. My understanding is the clues you looked for the physical sides were fast breathing.
For metabolic acidosis?
Yeah.
Yes, fast breathing.
Fast breathing, super sweaty or diaphoresis.
I think that'd be specific to the sympathetic nervous system. I don't think lactic acidosis by itself does the sweating, but yes, that would be seen in that process.
The tachycardia, the fast heart rate.
Yeah.
And I heard you say the cool and clammy would be a sign that somebody is actually more sick. So would that be, for example, if the metabolic acidosis is at a more serious rate and now somebody's in cardiac arrest, they might be cool and clammy?
If someone was getting sicker, typically when we see cool and clammy skin, it's usually a sign of, another term, hypoperfusion, which really just means kind of you're not delivering effective oxygen or blood flow to a certain area of the body. So when I see cool and clammy, typically that's what we're referring to, is it just kind of feels, like we've all probably felt it sometimes. You just kind of feel kind of clammy, and that's what we're referring to. It's not like you're cold. You're just not, you don't feel like you're room temperature.
Gotcha. When you talked about the majority of the literature and you were referring to a metadata analysis, a meta-analysis that talked about there were no difference in the side effects, whether you gave 5, and I'm going to mess this up, 5 milligrams per kilogram. Is that right?
5 milligrams per kilogram versus 7
So-
milligrams per kilogram.
So they studied, do you know how many people were studied?
I don't know the number of patients in each study. The meta-analysis had 10 to 15 studies, if I recall. And so a meta-analysis is not there's different degrees of what we consider to be great medical literature. Meta-analysis basically is trying to define or look at a broad topic of something. So it pulls a lot of similar studies that are smaller.
Gotcha.
And try to pull that together to say, okay, what are we seeing here? Because in order to have a really effective study, you have to have a lot of patients in a study. And so by meta-analysis, they basically pull these together and they have very similar guidelines to say, these patients got 5, these patients got 7, and then they're measuring different outcomes. And so they're basically they're reporting what the complication rates were for those individual studies.
Gotcha.
And trying to decide did they see a difference in that meta-analysis?
And these were things you considered when you were seeking the waiver. Is that fair to say?
Yes.
And in fact, when you were seeking the waiver, did you look at kind of rates or doses that were safe?
Well, yes, the doses are fairly well defined. 4 to 5 mg per kg is most common. In Colorado, it was actually somewhat told to me what we were doing. As I told you before, this is a waivered medication. And so the state of Colorado had, in order to get the approval to use it, you have this impact that has to approve your waiver. The common practice was you would use the same kind of dosing or protocol indications exactly as the impacts already approved for other agencies. At the time of 2018, I believe I was told that there was over 100 agencies in Colorado that had that waiver. So we just adopted this exact same indications, dosing, route, everything that the state had sent me is what was being approved by the impact. So that's why we modeled it.
Great. And I think when you talked about in 2000, I wrote 19, but in 2018 and then in 2019, when the protocol was in effect, as we looked at, there was no formal handoff of when the patient became kind of in custody, if you will, of EMS. Is that fair to say? There was no clear transition or delineation.
Yeah, there's no documentation I can aware of, it's certainly not in the protocols that says that there's a process that defines how law enforcement and EMS interact on a scene or when someone becomes from in custody over to the EMS person.
Is it also fair that you talked about when you create protocols as part of this broad Denver Metro consortium, and then you bring them over to AFR, you then do your tweaks? I heard you talking about that. How often do you adjust your protocols?
I mean, most of the adjustments are carried over from generation, like every protocol we have a bit the same thing.
Sure.
So in that way they're different. As far as me to actually add a new thing that's not in there, I mean, in the 7 years I've been the medical director there, or almost 7 years. Gosh, how many years is this now? Somewhere in there. I think it's probably been 4 or 5 times that I've made like a new protocol or an addition or something to that effect.
What about tweaking them?
I think I think if there are some protocols that you do adjust unique to your system. Like an example would be like intubation. We use video laryngoscopy. Not every agency does that. So our protocol specifically defines or talks about video laryngoscopy, which is basically using a video camera to do the intubation. So we made that protocols for us. I just took the intubation protocol from Denver Metro and put it in language, tweaked it to say that we use video laryngoscopy in Aurora.
So do you also adjust when you learn things? I mean, as you learn information or as you figure out?
Objection vague beyond the scope.
I'm not even done with the question, Judge, but
It sounded like it was going that way.
so when you fold in to your protocols, as you look at unveiling a new protocol, like in 2018, and you adapt it, do you look around and study all other protocols, or do you put in place a protocol and then adjust as you go?
Objection beyond the scope and relevance.
Response.
Judge, I don't think it's beyond the scope. It goes to exactly his mindset in putting together the protocol and the trainings thereon. And that's as far as I'm going with this line of questioning.
Okay, if that's as far as you're going, I'll allow it, but we need to be careful in this area.
Yes. Did you understand that question?
You asked me about, maybe you can repeat it one more time.
So in 2019, when you were looking at putting in place this protocol with adding in the ketamine, okay, did you do that with the intent of trying to make it as precise as you can, with the understanding you could always tweak it or add to it or modify it if you needed to later?
Yes, we always, so part of any medical director's responsibilities is you analyze a protocol, you have a protocol in place. If for whatever reason, whether it's new data, new evidence, new, what part of your review process, whatever it is, you can change a protocol.
Okay.
It's a medical director's discretion to change a protocol.
Okay. And do I recall correctly that you revisit your protocols quarterly? Is that right?
We do a formal release every 6 months, so twice a year.
Twice a year.
That we can do it more often. During COVID, we maybe had a couple new protocols that got rolled out because things were changing so dynamically.
Sure.
But generally speaking, it's twice a year.
Okay. If I could have just a moment. And Dr. Hill, I think it's abundantly clear, but is it fair to say Aurora Fire paramedics work under your direction and under your protocols as the licensed medical director and physician?
Yes, they have to do that.
I really appreciate your time. I don't have any further questions.
Thank you.
All right, cross-examination, and you'd find a convenient place to break in about a half an hour, 40, 45 minutes, something like that.
Good afternoon, Dr. Hill.
Dr. Ma'am.
I'll pick up where Ms. Bagan just left off. And in that role that you have as the medical director, one of your responsibilities is the training of the paramedics at Aurora Fire Rescue. Fair?
It's part of it's not solely my responsibility, but yes, there's a regulation that says I'm involved in the training of the paramedics.
And when you rolled out the new ketamine protocol, you were responsible for making sure that paramedics were properly trained on that. Fair?
Yeah, well, the department trains the individuals. I had a hand in developing the training. I did not deliver the training.
You applied for the ketamine waiver. Part of the conditions of the waiver is that that training would happen, correct?
Yes.
And it had specific requirements around it.
I have to look to see what the requirements were, but yes, I believe there was requirements.
And Travis Chambers and you worked together to develop the training that was given to Aurora Fire Rescue with respect to the new ketamine protocol.
Yes, there was some trainings. There was some interactions and inputs into the protocol, the PowerPoint, not protocol, PowerPoint that he developed, yes.
And you reviewed that PowerPoint and approved it.
Yes,
And in fact, you provided the videos, some of the videos that were used in the PowerPoint to illustrate patients with excited delirium.
sure, yes.
And I think you attended at least a few of those trainings to make sure that they were consistent with what your expectations were.
I think it probably was 2, and it was probably in the first week or so of this. I think it went on for several weeks.
Okay. I want to talk about a little bit more about excited delirium and some of the descriptions that you were giving of it. You'd agree with me that, I mean, excited delirium, it has certain hallmark features. Is that fair to say?
I don't know what you mean by hallmark.
Okay. Would you describe a hallmark of it as a person who's being incredibly combative and very hard to manage?
Many times they are, yes.
Okay. They don't seem to be connected to reality,
Ultramentation is consistent, yes.
not engaging in normal conversation.
They could be, yeah, I mean, I would say yes, they're not engaging me in conversation.
They're not engaging in conversation or not in normal conversation.
I think the way I would interpret it is like they're not conversing with me. I guess I would describe that.
Like if you asked them a question, they couldn't respond normally.
Well, yeah, I would not expect like we'd have a dialogue or something, like it would make sense to me.
So if they were responding in a way that made sense, that would suggest not excited delirium.
Could be.
They're commonly naked or partially clothed.
I've seen that both ways. It's not always the truth.
Okay. That was sort of true of the people in the videos that you picked for the training.
Yeah, I mean, unfortunately, there's actually, if you look on the web, kind of like you don't, at least back then, you didn't see a whole lot of videos. I think it's a little more common now, but I found what I could, and most of the videos that were on this, they showed people in various unclothed states fighting.
And that makes sense because, like you said, there are a lot of times they're hyperthermic, and so they're really hot, and their system is working overtime.
I don't know exactly why they take their clothes off. I mean, that's certainly a possibility, but I can't say for sure why someone takes their clothes off.
You'd agree that they would be acting very abnormal?
Abnormal, yes.
Okay. Cannot communicate?
I think, once again, communication, I think, is a two-part process. Like someone might yell something, but doesn't mean that I'm communicating with them. So they're not communicating with me, but that's what I mean by communicate.
They would need to be responsive to what they were hearing from you in order for there to be communication in the way you would describe it. And another hallmark is that they're not responsive to pain. Is that fair to say?
That's described that, yeah, they're often not responsive to pain.
And a lot of times the tools that police would use to restrain somebody that, like a taser, aren't even effective.
That has been described, and people get tasers that they will sometimes fight through that.
Okay, and that's been described by you.
Yes.
Yeah. Now, if we talk about the protocol 6010 that we've been looking at, that agitated combative patient protocol, that's not just for people with excited delirium, right?
No.
That would be for any agitated combative patient.
Yes.
Okay. And the vast majority of agitated or combative patients do not have excited delirium.
Response.
This is a topic on which this witness has opined before and described with respect to this protocol, what percentages of patients have, agitated patients have excited delirium.
No foundation in this testimony or this trial.
All right, if I'll allow it a different form with respect to his formulation of the protocol.
Dr. Hill, you drafted this protocol, correct?
Yes.
And in doing it, you were expecting it to apply to lots of different kinds of patients, correct?
Yes.
And the vast majority of agitated combative patients that you were intending to address with this protocol do not have excited delirium.
I think it's fair that the majority of patients that are agitated combative are not in an excited delirium syndrome. Yes.
Okay. In fact, excited delirium syndrome is pretty rare.
Objection, foundation, speculation.
He's been endorsed as an expert in excited delirium by you.
All right, I think tighten it up.
Would it be fair to say that the number of patients that you would expect to fall under this protocol that you drafted, only a small fraction would have excited delirium?
Yes, it'd be a small number.
And part of the protocol, the way it's laid out, is to sort of sort out who's just an agitated combative patient versus who actually has excited delirium. Is that fair to say?
Can you reword it for me a little bit? I'm not totally sure I understand the first part.
Sure. Is it fair to say that there are a lot of mimics for excited delirium?
I think there's a lot of causes for it, but yes, I mean, I think there's other mimics that could present in that kind of a state. Yes.
Okay. And you trained on those in the training that Mr. Chambers prepared?
I think there was listed of some mimics or some things that could present in a similar fashion. Yes.
Okay. And it could be somebody who's on drugs might present like they had excited delirium.
Sure. I mean, the number one cause of excited delirium is drugs, but yes, you could also be drugs without excited delirium.
You could be having a mental health problem other than excited delirium.
Yes. Yes.
You could have hypoxia.
I don't think hypoxia would really present as excited delirium. It could present as combative altered mental status,
Mhm.
but yes.
You could have low blood sugar and present as agitated and combative.
Yes, you can be agitated and combative and have low blood sugar.
And so part of the initial part of the 6010 protocol is to ask some questions for paramedics to go through to sort out who is just agitated and who might have excited delirium. Is that fair?
I don't see questions there listed.
Okay. Do you want us to pull up the protocol?
Sure.
Exhibit 219. Thank you. So if we look at that top left corner of the protocol there, there's several steps that paramedics would go through to apply this protocol. Fair to say?
Yes.
Okay. And that would include asking whether the patient is a danger to himself or others.
You're not asking them. That's are you thinking that they're a danger to themselves or others? That's not an
Right.
ask.
You would ask yourself, is this patient a danger to himself or others?
Yeah.
Okay. You would make a judgment about that.
It's your interpretation.
And then you would attempt to reasonably address the patient's concerns.
In some situations, you can do that.
Okay. Wouldn't that be reasonable to do in all situations?
There are times that is not possible, but if you can de-escalate, that's obviously more advanced. That's a preferred method, but that is not always present.
If you can address a patient's concerns, you would want to do that.
Sure.
And then it says, assume the patient has a medical cause of agitation and treat reversible causes. Do you see that?
Yes.
Okay. And you would want to do that. You would want to look for medical causes of agitation and fix them if you could.
Yeah, the purpose of this is to say that if they're agitated combative, you want to don't assume it's just agitated combative, assume it's a medical thing, and then as part of your treatment, you should be looking for reversible causes.
Mhm. And the first step that you would follow in addressing an agitated combative patient would be to try to verbally de-escalate them. Is that fair?
As I said, there's times you can do that, there are times you cannot do that.
If you can do it, you should.
If the situation I had thought that I guess I could de-escalate them, then yes, I'd prefer to do that as opposed to using restraints or anything else. But it's not always applicable to the situation. It can't always happen.
Okay. But again, if you can do it, you should.
If you can de-escalate them, you should try to do that.
Now, I think you covered the fact that we can take that down now. The reason that you're giving somebody ketamine if you think they have excited delirium is because you're worried that they're going to exhaust themselves or get to a point where they would go into cardiac arrest. Is that true?
I think it's the purpose of giving them the ketamine is to stop the physical fight, which if continued in their metabolic acidosis would potentially cause them to go into cardiac arrest.
And if you didn't have ketamine, and you thought you had a patient who had excited delirium and was at risk of going into cardiac arrest, how would you prepare for that?
You know, admittedly, when we made this protocol, I did not foresee a situation where you would be on scene with this condition and not have the medication available. So it's not defined, and I did not give them any guidance on that.
Well, in the years prior to authorizing ketamine, you didn't have it then to treat excited delirium, right?
It's true.
Okay, and so if you were in a situation where you had an excited delirium patient and you were worried that they were going to go into cardiac arrest, what would you do to prepare for that?
What would I do to prepare?
What time period, I mean, the questions are vague, I'm objecting.
Sustained.
Let's talk about the time period just before you had ketamine authorized, okay? And you're a paramedic for Aurora Fire. And you're in a situation where you think you have a patient who might imminently cardiac arrest. What would an Aurora Fire paramedic do in that situation to prepare for it?
Objection, relevance as to what an Aurora Fire paramedic would have done before ketamine was available.
I'll sustain the objection if it can be related to a protocol that existed prior to that, or shortly prior, I guess.
Let me just
Allow the witness to answer.
Let me just back up and ask it this way. Would you expect if you had paramedics that were at a scene where they might need to treat a cardiac arrest, that they would have certain equipment with them?
Yes, if they were on a cardiac arrest, they would have their equipment.
What equipment would that be?
For cardiac arrest,
Yes.
you usually have it's all your kits. So it's your ALS kit, your medication kit, cardiac monitor, oxygen bottle.
And what tools do they have in order to treat a cardiac arrest if it happens?
So they have their cardiac monitor. They have a device called an intraosseous needle or IV supply so they can get vascular access. They've got medications. They perform what's called advanced cardiac life support. So they have life-saving medications and fluids. They have airway materials, intubation supplies, things of that nature to manage an airway, and an oxygen bottle.
I want to talk about if a patient's condition changes over time. You would need to reevaluate your plan of treatment. Is that fair to say?
You're saying that the person recognizes there's a change in condition?
If the paramedic recognizes there's a change in a patient's condition, they would need to reevaluate their plan of treatment.
Yeah, if you are on a treatment pathway that you're going down, if you recognize something has changed, you should make a determination if you think you still should go down the same path or different.
I'm going to talk about, let's go to Exhibit 250, please. Part 2, Slide 12.
And I'm going to object, this is outside the scope of direct.
I don't know what it is.
It's a slide from the judge chambers training. Not inquired about on direct exam.
Response.
Your Honor, this relates directly to Dr. Hill's testimony regarding dosage and risks of ketamine.
All right, I'm going to allow a small bit of leeway for cross-examination based upon that area of inquiry.
And Dr. Hill, this was one of the slides provided in the ketamine training. Is that fair?
I do believe so, yes.
And you seem to be suggesting that respiratory depression wasn't such a big risk for ketamine. Is that how I understood your testimony on direct?
Yeah, I'd say that, intramuscular injection of ketamine is rarely associated with that kind of condition.
Okay. And in this slide, though, you did choose to identify respiratory depression as a specific risk of a large dose of ketamine.
Objection, argumentative, facts not evidence. Drafted the slide.
All right, if you can clarify.
Dr. Hill, this is the training that you worked with Mr. Chambers to prepare.
The training in general, yes, is the training I approved. Travis Chambers made the slide.
Okay, and you approved this slide as part of the training.
I in general approved the training protocols, the training PowerPoint that he made, yes.
And in this training, paramedics were instructed that respiratory depression is a risk of a large dose of ketamine. Is that fair to say?
I think that's what it says there, yes.
Okay. And that everyone gets 500 milligrams practice is not a good practice because it is a weight-based drug. Is that fair that that's how your paramedics were trained?
I believe that's how I don't know what he exactly was thinking when he put that in there, but I think that I think the intent is to say that there should be some kind of a determination of weight, just to say that everyone gets 500. You want to make some kind of determination of your weight and then choose your dose.
Right, based on the patient's weight to your best estimate.
Yes.
And I think you said that one good way that paramedics use to accurately estimate weight is to know their own weight.
I think that's a valid method. I don't know if it's their method, but yes.
Is asking the patient a good way to estimate weight?
If they're conscious and alert and can talk to me, yes.
We need the exhibit.
We can take that down. Now, with respect to the monitoring of a patient that's been given ketamine, once the patient is physically sedated and they're not resisting, you would want to get them on a cardiac monitor right away. Is that fair to say?
I think in this situation, you want to apply the cardiac monitoring. I don't think the protocol accurately reflected that, but yes.
Okay, but that's what you would do. I mean, that would be the best practice to get somebody on as soon as possible.
I think once I had someone, if they were in a sedated state, a common practice for me would be to apply my monitoring equipment. And it's not defined about how long exactly, but it's within short order.
Dr. Hill, I don't have any further questions.
Thank you.
All right, that went a little quicker than I thought, so if you can perhaps in another 20 minutes or so.
I will not go that long. I
Okay.
promise.
All right.
Maybe a quick stretch break.
Oh,
I'm not.
Yeah.
I'm not opposed to that, but
okay, yeah, that sounds like a good idea.
I'll look at them.
Sometimes should be 5 seconds.
And there was no difference. On top of that, it's like
Thank you. Thank you, Your Honor. Dr. Hill, you were asked some questions by the prosecution regarding hallmarks of excited delirium. Do you recall that?
Yes.
And those hallmarks that Ms. Stevenson went through with you, and there were several, are those hallmarks always present and in every case?
No.
Okay. Are they some of the things that historically have been seen by medical professionals who have treated excited delirium cases?
Yes.
Okay. I noticed that in the protocol, People's 219, the agitated combative patient protocol, what the box that talks about excited delirium that we've all seen numerous times, so I'm not going to put it up again, talks about looking to see signs and symptoms of which some or all may be present. Do you recall that language?
Yes.
Okay. Why use that language that some or all might be present?
Because I would not want them to identify successfully, there's no magic number of how many of these symptoms you have to have. So if I said you have to have 4 or 5 and they had 3, then they don't treat, but that could be a bad outcome. So we just say some or all to give them the idea of this is the types of signs and symptoms you're looking for in the setting of an agitated combative patient.
And you made a distinction in your testimony earlier, I think on cross-examination, that paramedics don't make diagnosis. They don't conduct diagnosis. Is that right?
That is true. The paramedics do not make diagnoses.
Okay. Is that also one of the reasons why you trained them to look for some, but maybe not all, of the signs or symptoms of excited delirium?
Yeah, to be fair to myself, in an emergency department, I don't have a diagnostic test to rule this in or out. The purpose of it is to say that, when paramedics are trying to decide on their treatment pathway within a protocol like this, they're taking the information they've obtained and trying to apply it to the protocol and saying, what do I think is best in this situation? And so it's a clinical impression, but it's not really a diagnosis.
Okay. You were also asked some questions about the percentage or the number of people that you would expect to have excited delirium. Do you recall that line of questioning?
Yes.
And it was in relation to, as you were drafting this protocol, the 60-10 protocol. Do you recall that?
I recall the question. I remember the question about what percentage of patients would have excited delirium on this protocol.
You talked on direct about the purpose of the waiver, the ketamine waiver, to address excited delirium. Did I hear you correctly? Was one of those reasons that you and the medical professionals in Aurora were seeing an increase in the frequency of people with excited delirium?
Yes.
Object outside the scope of cross.
Response.
She was asking whether or not the doctor's expectation of this protocol, so presumably Aurora, that a small number of patients would actually suffer from excited delirium. So I'm following up on that.
All right, the court will allow it.
So I'm sorry, just so the jury hears your answer, was one of the reasons that you sought the waiver for ketamine to treat excited delirium, was one of the reasons because you were seeing an increase in frequency of patients with excited delirium in the greater Aurora metro area?
Yes. What I was trying to say there is that the number of patients over in total, over like years, it's not the majority, but we were certainly seeing an increase. And that was particularly around a particular substance that was in Aurora at that time, an illicit drug that we were seeing. And that's what we were particularly identified as the need as to why I pursued the waiver to begin with.
Would you categorize the rate of occurrence of individuals with excited delirium in Aurora, Colorado, between 2018 and 2019 as rare?
No, it was more common.
Okay. You were asked some questions sticking with the agitated combative patient protocol, and you were shown kind of those first 2 boxes on the left-hand side of the protocol. In one of the boxes, the first box essentially indicated, determine whether or not, well, can we put up the protocol, Cole, exhibit 219? Determine whether or not the person is agitated or the patient is agitated and a danger to self or others. Do you recall getting questions about that?
Yes.
And that's a determination, a judgment call by the paramedics. Is that fair?
Yes.
Okay. The second box down says, assume the patient has a medical cause of their agitation and treat reversible causes. Did I read that right?
That's true.
Okay. Is excited delirium one of the many medical causes that can cause someone to have agitation?
Yes.
If you believe that excited delirium was the cause of the patient's agitation, does this protocol direct paramedics to then treat that excited delirium?
The intent of that box is to make people reflect that, once you're able to do so, you want to be able to treat or finish your evaluation of your patient and initiate treatment. So, treatment, excited delirium is life-threatening. Yes, you treat it, but once you treat it, you have to look for the causes that caused it to begin with.
Okay. And so initially treating excited delirium, how do you treat that?
You treat that with ketamine.
Okay. If we can take that down, and Cole, can we put up, I believe it's the same slide that the prosecution used, Exhibit 250, Part 2. I think it was slide 15, but maybe just show it to me first. Slide 12. Okay, thank you. Okay. You were asked questions about respiratory depression on this slide. Do you recall that, Doctor?
Yes.
Okay. And that's the second bullet here that talks about the large doses increase the likelihood of harmful side effects. And then in parens, it says emergence reactions, laryngospasm, and potentially respiratory depression. You see that?
Yes.
Okay. First of all, do you consider 500 milligrams of ketamine delivered intramuscular to be a large dose?
Objection, lack of foundation and outside the scope.
Let me rephrase. I can ask a better question. In the context of this, sorry, is that over right, Your Honor?
You can rephrase.
Okay, thank you. Cart before the horse there a little bit. In the context of this training, where it says large doses increase the likelihood of harmful side effects. First of all, it says potentially respiratory depression. Explain to the jury what that means.
Potentially means like there could be some respiratory effects on someone at a very high dose of the ketamine. The literature is mostly around, the overdoses of prescribed literature are very high doses, 10 times more than you're supposed to get, kind of a thing. But that's really what it's talking about. It's saying like, maybe there could be some respiratory depression there, but we can't be for sure.
So just to be clear, when you're talking about large doses increase the likelihood, what you're saying is the literature suggests that large doses are like 10 times what the person should receive? Did I hear that right?
Objection, lack of foundation as to this witness's adoption of that statement and beyond the scope.
I'll sustain that objection.
Okay. What is meant by large doses here in this training?
Objection, lack of foundation.
Response.
I guess I'll give the AG's response. He approved this training, and it's a training that was provided to the paramedics, and Ms. Stevenson was allowed to ask some questions about this training in this slide. So I'm operating in similar fashion.
Overruled.
What does large doses mean in the context of this training in this slide?
We did not define it. I think what we were trying to say is that if you give, very large doses of a medication, you're going to increase your side effect profile. It was not intended to say that the doses that we're using are in any way large.
And when you say the doses that we're using, you're talking about the doses that are approved under the protocol. Is that right?
Yeah, the maximum dose they could give at one time would be the 500 milligrams.
Okay. And so to be clear, that dosage, that maximum dosage is not what is being referred to here as a large dose.
Correct.
Thank you, doctor. I have no further questions.
Thank you.
May the witness be excused? You may step down. Thank you. Yes. Further evidence or testimony on behalf of Mr. Cichuniec.
Your Honor, on behalf of Mr. Mr. Cichuniec's defense rests.
On behalf of Mr. Cooper.
And based on all the evidence presented, we rest on the record, Mr. Cooper.
All right, folks, the defense has rested. There's some decisions I need to make outside of the presence of the jury. So we'll give you your long break. So we can go downstairs and maybe, I heard it was supposed to be really nice today. I don't know though. So at least you can stretch your legs and go out into the courtyard if you would like to do so. But again, as I've told you, every time we break, don't form or express any opinions, discuss the case. Let the court know if somebody tries to discuss the case with you. Do no independent research, avoid any press coverage about this case or this kind of case. Hopefully we'll see you in 15 to 20 minutes. All right, the jurors have stepped out. Please be seated. Motions on behalf of the defendants. Right, you know, I suppose we should probably discuss the other issue first. Now that I thought about it. I put the cart before the horse on that one. All right. The court was informed at the bench that there's potential for some rebuttal evidence to be presented by the people. I kind of need to know what your thoughts are on that on behalf of the people.
Your Honor, I think that there are two issues that are potentially ripe for rebuttal testimony in this case. The people completed our case in chief, fully prepared to let the jury look at the protocols and the training and make a determination of whether the behavior in this case was reckless or criminally negligent. Defense then called 3 standard of care experts, Dr. Ludwig to testify about the standard of care nationally, broadly, and globally, as well as locally. Then Ms. McKinley to talk about just the Colorado protocol standard of care. And then finally, Dr. Hill here to just explain the protocols themselves. In light of that expert testimony, especially including the testimony that the defendant's actions met the standard of care, and the defendant's own testimony, which of course we could not anticipate that they would testify, and then also say that they acted within their training and their protocols. I believe that opened the door to rebuttal evidence, specifically expert rebuttal evidence on the standard of care issue. The second issue, Your Honor, is that we had no way to know what the defense theory on medical causation was going to be, especially given that Dr. Dragovich and Dr. Sundaram's opinions completely conflict. We didn't know if they would call one of them, both of them, none of them, because Dr. Dragovich says that large volume aspiration killed Mr. McClain, and Mr. Sundaram rules that out and says it's actually the narrow left anterior descending artery that caused cardiac problems and killed Mr. McClain. Specifically, Mr. Sundaram's testimony, I think, requires rebuttal, and that would be, of course, of an expert nature to address his contentions regarding the carotid or the narrowed coronary artery in order for the jury to get the full picture, especially in light of the fact that Mr. Sundaram admitted that there were a number of materials that he did not view, such as the microscopic slides related to the heart or conversations, and he did not have conversations with other expert witnesses who are familiar with it, like Dr. Sina, Dr. Mitchell, or the people's other retained experts. For the general proposition that a rebuttal case is appropriate, I think People v. Welsh is sort of the headline case from the Colorado Supreme Court, can be found at 80 P. 3rd 296. And the key guideline that the Colorado Supreme Court gives there is, and I quote, "Unlike impeachment evidence, which is more focused on the credibility of an individual declarant, rebuttal evidence goes to the heart of the case, reflecting upon the truth of facts upon which the other side relies. Thus, rebuttal evidence is essentially substantive in nature." People v. Welsh goes on to say, "Any competent evidence which explains, refutes, counteracts, or disproves the evidence put on by the other party, even if the rebuttal evidence also tends to support the party's case in chief." So I think within those definitions set forth in People v. Welsh, this would be appropriate rebuttal evidence. If the court wants to do any further reading on the issue, the Supreme Court also opined in People v. Silburn, Silburn, which could be found at 807 P. 2nd 1167, also discusses a lot of the same general issues. So in light of those two things, I think the people would be requesting permission to put on a brief rebuttal case. As I mentioned at the desk earlier, I believe direct testimony would be less than 2 hours in total, in light of the fact that the defendants have put on over a 4-day-long case with all of these experts that we had no way of knowing that they would get into. It would be appropriate and fair to allow the people to at least put on that very limited couple of hours of testimony.
Okay. Yes, on behalf of Mr. Cooper.
Your Honor, we strongly disagree. To suggest that the people were not on notice, they started this case in 2020 to 2021, and they are who brought Dr. Hill before the grand jury to discuss standard of care. They have put on notice the standard of care issue this entire time, and to suggest they didn't have notice of who we might be bringing forth or what the issues were is disingenuous at best. As to standard of care, it's their burden to prove it, and it's our defense was to bring in people to talk about what it's like to be a paramedic. Contrary to what the Attorney General is articulating, Mr. Ludwig did not, despite how hard they tried to get him to go there, talk about national standard of care. They are trying to open the door to the national standard of care because less than a month ago, they endorsed a medical director out of Minnesota. And they want to go to the national standard of care, not the defense. That's what they're trying to do here, Judge. As to cause of death, they want to bring Dr. Buther back in to talk about not being a cardiologist, but to impeach Dr. Sundaram. He's already talked at length. He thinks he's an expert in pretty much any area, but he's been discussed. He testified on direct and on cross at length about what areas he's qualified in and what areas he's not qualified in. To suggest that they should bring him back to rebut Dr. Sundaram or Dr. Dragovich in the two areas he has absolutely and unequivocally said from the stand he is not qualified in, forensic pathology and cardiology, because they want somebody to address those issues, again, is
No, I'm sorry, who?
Dr. Buther, the
Okay.
pulmonologist. That's just, they're trying to dress it up as he's a critical care doctor who sees EKGs and echoes. He doesn't interpret them, cardiologists do, but they want him to talk about it. Judge, they have had all of our expert reports and endorsements, with the exception of Dr. Dragovich, for months. And to suggest they didn't know what they were going to testify about, I think we all saw how they picked apart those reports. I think they were on clear notice of what the witnesses were going to say and not going to say. With respect to Dr. Dragovich, I would think that they like the fact that witnesses contradict, although I dispute their classification of that issue. It is very clear and has been the longstanding case law in this jurisdiction in People v. Eckhart, 247 P. 2nd, 673, Colorado, 1952. Rebuttal testimony is not appropriate when it's putting things on that could have been offered in the people's case in chief. So what they did here was cut Dr. Hill to try to put it so we had to call him to try to open the door to putting on a rebuttal case. And Judge, what's equally clear, and I can give you a lot of sites, but sir rebuttal, if there is a rebuttal case, the general rule is the defense should always be allowed to present sir rebuttal to discuss what the prosecution brings in. You can go through Brockman, citing to Hutto, citing to Berry v. People. This goes back to the turn of the century. We're talking 1900s.
Before we had the rules of evidence?
and it continues though, Judge. The case law still stands to this day under Martinez in 73, Terry in 86. This
73 was rules.
86.
86 would be post. Unless it took the appeal to get through too long.
And right, Terry says it's well settled that the trial court should permit the defense to introduce sir rebuttal to respond to matters presented on rebuttal. Fairness requires that a defendant be permitted to oppose information presented by the people that the people could not have known during the presentation of their case. So Judge, we're just going to open up, and I'll tell the court as an officer of the court, based on the fact that we knew about Dr. Wesley about 3 weeks ago, we have two potential, one for Mr. Cooper, one for Mr. Cichuniec, two potential rebuttal experts as to this standard of care issue. As with respect to Dr. Buther, we learned of this last night. So we are not in a position to respond, and we would ask the court to strike any and all rebuttal testimony. It is not appropriate. This is not a situation where the people were not on notice. It's hard to envision a case where they've had more time and more preparation to know what's coming than this one.
All right, well, I'm not Steve Menard, so I don't remember the site to Martinez, the 86 case you referred to.
Oh,
So
I apologize, Judge. It was Terry.
Terry?
Yeah, 720 P. 2nd, 125. Martinez was 506 P. 2nd, 744, but that was 73.
Okay.
And Eckhart was 52.
All right, looks like I have some reading to do. Well,
Your Honor, just to complete the record, can I join my colleagues' comments and also add that the standard of care in terms of anticipation of testimony and evidence regarding the standard of care, it's in the elements of one of the pled charges against the defendants in this case. So a gross deviation from the standard of care. So there's no way they couldn't have anticipated this.
Anything else?
No, Your Honor.
All right, well, are they down in the jury room? Oh. I thought they usually went downstairs. All right, any further record folks want to make?
Judge, in the case cited by the people, Welsh ADP 3rd 296, Kahlo 2003, I think it's important to note that in that case, the Supreme Court reversed a first-degree murder conviction, insanity defense, because they said the trial court abused its discretion in allowing the rebuttal case. First and foremost, I also want to point the court to part of the logic the people articulated in picking up where Mr. Lowe left off was the standard of care. Under the criminally negligent homicide charge, that requires the people to prove that there was a gross deviation from the standard of care. The people have been trying to open the door to a national standard. That is a separate argument later to be made, but we have been absolutely opposing that. That was sort of articulated and brief with a witness that we did not call. Judge, we also did not call an out-of-state standard of care expert, Dr. Carroll, who was a medical director, specifically to avoid any national standard of care discussion. Mr. Ludwig never testified to standard of care. In fact, he only testified to protocols. Ms. McKinley, she was narrowly tied to only the local standard of care. The court very constrained her testimony. She was not allowed to talk about anything from her own training and experience. It was all only as under the Aurora Fire standard of care. Her testimony is extremely tightly constrained. We did not call 4 other professional experts that we had. Part of that was timing. The people took 7 days for their case presentation. We took 4. We cut and short-circuited because the court has been very clear about wanting to get this to the jury. To now say that, and I would articulate also that the court also cited in Ms. McKinley that she could only discuss the training and materials, and she was not allowed to go into patient assessment. She was not allowed to go into anything of that nature. That's all stuff they're trying to get through this national standard. But the people that were allowed to do that were Dr. Robinson and Dr. Mitchell, who treats dead people. So to suggest that they were not on notice about this and they didn't put on evidence about it, they absolutely put on evidence about standard of care through Dr. Buther, through Dr. Robinson, through Dr. Mitchell. And we had a right to respond to that. That does not open the door to a further response on standard of care. If the court's going to allow it, we also have argument as to their proposed expert, and we have 2. Mr. Cooper has 1, Mr. Cichuniec has 1, standard of care rebuttal experts.
Yes, you mentioned that before.
Yeah, and as to cause of death, Judge, I'll stand on the record we previously made unless the court needs further argument as to that. But we would not be in a position to respond at all, given the late timing of that.
All right.
Just briefly, Your Honor, and perhaps from a more global perspective, it seems to me that the rebuttal case, at least with respect to Dr. Sundram and Dr. Dragovich's testimony, that they are calling or alleging that they have a rebuttal case to essentially challenge the opinions of those 2 doctors. They have already put on 4 cause of death witnesses that challenge those doctors' opinions. And so any further testimony by experts brought to challenge those 2 testimonies would be cumulative. And I join the other comments of my colleague.
All right, any further comments for the people?
Judge, as a threshold matter, I think the defense is misapprehending where the right to rebuttal comes from. It's not whether we could have anticipated their defenses. It's whether or not they put on evidence that raises new issues that weren't addressed in our case in chief. Taylor v. Mazzola addresses that, 375 P. 2nd 96. And I quote, "A party is not required to anticipate testimony the opposing party will offer in defense." And that's obvious, particularly in criminal cases, because we don't know if the defendants themselves will testify. And as Ms. Began pointed out, They've got a bunch more experts that they endorsed and gave us reports from that they ended up not calling. We had no idea what to expect. But the relevant thing is that they introduced during their case a new issue, which is expert opinion on the paramedic standard of care, specifically whether the paramedics performed a proper assessment. That was Mr. Ludwig's testimony. Whether they were using their equipment properly, Mr. Ludwig's testimony. Neither of those things are based in the protocols from AFR. Those both refer to generalized concepts of paramedic standard of care, and and as Mr. Ludwig describes in his report, those are all based in the national standards. He did actually testify that the national standards were the basis for his opinion. So I do not think it is factually correct to say that they steered carefully away from that testimony. But then they called a second expert witness, Ms. McKinley, to testify again about specifically paramedic standard of care. And that's very different than the expert testimony that was offered in the People's case by Drs. Buther and Mitchell and Robinson, which are about ketamine specifically. And the court confined their testimony to their experience as medical doctors in administering ketamine or being familiar with it. We were specifically prohibited over defense objection from asking about paramedic standard of care from those witnesses. So we were not able to get into that with those witnesses. And now that they have introduced that issue in the form of expert testimony, we need to be able to rebut it. So I think to that extent, it would be well within the court's discretion to permit a short rebuttal case that would still keep this, or excuse me, a short rebuttal case that would keep this on track. And if there is an issue raised in the People's rebuttal case that was not addressed by one of their experts already, then we can talk about whether they get a rebuttal case. But the court doesn't need to decide that right now. And I think it would only be appropriate if something comes up in the rebuttal case that was not already addressed by one of their experts.
Your Honor, may I clarify? Right?
Oh, sure.
I believe that the only testimony from Mr. Ludwig regarding the standard of care was on my examination of him on behalf of Mr. Cichuniec, and my questions were specifically tailored, and I believe the court actually overruled an objection from the prosecution during my examination that I was referencing those questions specifically with respect to the AFR standard of care as he reviewed them. I just want to clarify the record on that. I do not believe that Mr. Ludwig testified to anything other than the local standard of care for AFR during his testimony.
All right, the matter comes before the court. I suppose the issues are whether or not to allow a rebuttal case. There's two, I suppose, areas of inquiry that are being sought. One is the paramedic standard of care that was testified in large part on the defense case. There was some witnesses that tried to dip into it during the prosecution's case, but the court generally disallowed that. The other, I suppose, would be, unless I'm misunderstanding this, would be the cause of death. That would be with respect to Dr. Dragovich's testimony, as well as the cardiologist. The court would note, first of all, that based upon the opening statements of counsel and their examination of the witnesses, really the linchpin issues in this case have been standard of care and the cause of death. The court would note that, at least to a certain degree, even the prosecution experts disagreed to a certain extent on the cause of death. And the manner of death, the court doesn't find quite as relevant here, but the cause of death certainly. Dr. Sina, in fact, contradicted himself to a certain degree and was different from the testimony, specific testimony with respect to cause of death of Mr. McClain by Dr. Mitchell. The court notes that really the linchpin issues here that the testimony is circled around is either reckless, which a standard of care is really inferred in that disregard of a substantial and unjustifiable risk, the result will occur, a circumstance exists. And the criminal negligence specifically deals with a standard of care issue as well. Here the court, the jurors have heard from numerous witnesses that gave somewhat varying accounts on really what ultimately what they believed caused the death of Elijah McClain, including the contributory factors that were testified to, again, by a number of the witnesses in the case. The other issue, I suppose, that the standards of care, the court would find that the jurors have heard plenty of testimony, either implicit or explicit, about whether the standards of care were followed or not followed, and there are different accounts of it. The court does, and I carefully read the Welsh case, and I read the verbiage in it, and I don't necessarily find it terribly persuasive in that. There we're talking about a constitutional issue, which again, it was discussed in detail, but the court, based upon all of those circumstances, and I think it was whether it was an insanity case with post-arrest silence. It was really the big issue in the case, and the intent of bringing the evidence in was to show that the defendant in that case, Ms. Welsh, was in fact sane because she didn't say anything after she was arrested. So while the black letter law in the case the court finds enlightening, I suppose, the court would find that based upon the totality of the circumstances, the court will deny the request for rebuttal. All right, where do we go from here?
I would ask, we bring the jurors in and release them. We could talk about, we could do our motion outside the presence of the jury. And then we could get the instructions sent to the people. Perhaps counsel could be back early to hammer out instructions. The court could then copy them, and we bring the jurors back to do closing arguments. So we just figure out what time, and we do jury instruction argument in the morning, copy instructions, and have the jury here to have instructions read and then arguments.
Any suggestions? I was going to go across the aisle. People.
Yes, Judge, I think that's reasonable. Excuse the jury from instructions tonight. We can review them tomorrow morning. The only question is, what would be a reasonable time to ask the jury to come back?
And that is dependent upon the length of the arguments of counsel. With respect to the jury instruction issues we may have, I'm not sure what to expect. I suppose, thinking about it, I would hope that by 1 o'clock we could have jury instructions put together for the jurors.
Judge, we're not going to have time. I think prior timing was 70, 70, 90, 60, 30, I think was the amount of time. So
I think it's 70, 40, 40. My math says 2.5 hours.
And I think we can certainly be done.
And I try not to be terribly flexible with well, no, I mean with the length of closing argument, and I kind of base it upon the issues that are raised during the trial. So if I said 60, 30, 30, I certainly don't mind expanding it to 70, 40, 40.
Oh, I apologize. We wrote down that you had said 70, 70, and 30 for opening and recording. That was what we had. I don't know, maybe I totally misheard that. So we were.
Yeah, I don't give timeframes for rebuttal close. That's whatever you have left.
Just articulating, then we will, whatever you say, Judge, we'll make it work.
Mr. Slaughter?
Well, Judge, the last two times you asked me this question, I started off by saying I would ask for 90 minutes, but I know that that's only a bargaining position. And I was going to actually hope for 70, which is what you gave us in the last two. This trial, Judge, I actually really do think we need 90 minutes. I mean, the number of experts, especially from the defense, and the fact that we are not allowed to have a standard of care expert rebut them means that we're going to have to argue their standard of care experts just in closing, which we can do. We'll do it, but it does take time. And I really do think that we need 90 minutes. So I would suggest 90, 45, 45 or 90, 50, 50 if the court was going to keep with its prior system. If the defense thinks that we can get through jury instructions reasonably quickly in the morning, maybe we could even read them to the jury before lunch at 11 o'clock, read the instructions from 11 to noon, take their lunch break, and then have them fresh and awake for closing arguments in the afternoon.
Well, I guess I'll trust what the officers of the court tell me, and that is that we're not expecting a marathon with respect to the jury instructions. I've gone through the people's submissions and just made some adjustments based upon some earlier rulings from the court. Not many more there. The other thing I focused on was the Colgi modified that was in parents. I think there probably end up being some discussion about that. So as I see it, that's 3 hours. If I like your bargaining position argument, so I was going to do 80, 50, 50, which would be 3 hours for closing argument. I'm going to say if I speak very quickly, usually 45 minutes. I think that's been about what I've taken before, but I'm not sure.
Vice Judge, if perhaps we bring the jurors back, we read instructions, we do first close, take the break, do the defense two closings and the rebuttal close. Because I don't want to bring them in at 11, read instructions, they break for a lunch, and that seems silly. So I think whenever you want to bring them in, we do instructions first close, then they can have a break, defense close, and then the vote. Send it to them. Beyond that, whatever time you want, but I just don't think it makes sense to keep them in break.
Your Honor, there's always that guy. I'm that guy. I can't speak for court staff or co-counsel, but in order to ensure my target time for you to be reading instructions would be 10 a.m. I can be here at 8 a.m. to make sure that we have enough time for arguments. I think 2 hours.
Well, you have to calculate in the time as well that I'm more familiar with, and that is the copy machines are no quicker than anybody else's. And that process in and of itself takes about half an hour of just getting them printed and put together and passed out and all of that. So the argument with respect to reading the jury instructions and then breaking, the jurors are all going to get copies of the instructions, so they'll be able to read them again if they need to. I don't find that to be, so I'm going to shoot for 11. Let's get the jury instructions done. I'll read them. And then we'll start at 1 o'clock for the closing arguments. With the break, with the timeframes that I've allowed for counsel, that's 3 hours, and then there'll be a half an hour, or somewhere around there. It's usually a little longer. We'll allow them to go downstairs in the afternoon, so another 20 minutes. So there'll be 3 hours and 20 minutes. So If things go as planned, we could send the jurors back at roughly 4:20 or 4:30 and at least get their foreman or foreperson selected. It's about as far as they'll get, I think.
I don't know if you did this in your prior trials, but I would request that the court make a very explicit instruction during deliberations and even for the alternate, they stay far away from any during that time. And I've had it where the jury's out and we have to call in an alternate, but they I hate to go this far.
I generally give that instruction to alternates. And of course, the jurors, hopefully they've understood. I've explained the same thing dozens of times. So, okay. All right, our jurors have returned. Please be seated. And the court recalls 21 CR 2800 and 2806. Folks, I apologize. My estimation on time wasn't nearly as accurate as I hoped it would be. But the court did have to make some determinations that outside of the presence of the jury. So I apologize and I thank you for your patience. The prosecution is rested. The defense is rested. If you can remember back when I explained jury instructions, those are the rules of law that you must follow in making your decision or decisions. And those are just as important as anything else in the case. So we're going to get likely started early in the morning, tomorrow morning. I'm confident we will be ready for jury instructions and closing arguments at 11 o'clock. So once again, I'll remind you with emphasis, we've all spent a great deal of time in this case. And it's very important that I've probably went a little quickly when I was explaining the rules for the jurors. But I want to reemphasize that it's very important, especially based upon the time that's been spent by you folks and everybody else in this case, not to form any opinions or express any opinions about the case. You shouldn't be discussing it with anybody. If anybody tries to approach you, you should make me aware of that so I can attempt to remedy that situation. Oftentimes, it's mighty tempting when we hear certain things, and we've heard certain terminology over and over and over again during this trial, but there may be some things that you heard once or twice that you really weren't sure about. It's not the time to look things up on Google or the internet, or in any dictionary or medical journal or anything of that nature. Again, there's been press coverage in this case. I've had to turn my radio off on the way to work a number of times because I try to do the same thing. So with that, going to excuse you for the evening. Would like to have you back together at 11 o'clock. And the only thing I'm going to request that you do, we've kind of changed our protocol, if you will, for bringing folks up in the little elevator. But I just encourage you to stay on that end of the building until we bring you into court. It's just to avoid any other difficulties we might have. So with that, I'm going to excuse the jurors until 11 tomorrow morning. Have a nice evening. Drive safely. All right, please be seated. Now, I think I'm ready to address motions on behalf of the defendants with respect to the accounts.
Your Honor, on behalf of Mr. Cooper, at this time, I will stand on the record as to the reckless manslaughter and the criminally negligent homicide count, and as to the second-degree assault bodily injury count. My argument is focused at the allegation of second-degree assault, what we, I don't know, we refer to loosely as drugging victim count, and specifically also the sentence enhancer. Judge, I think in this case, what is critical to note is that there has been absolutely no evidence that at any point in time the defendants used ketamine for anything other than a medical treatment. The argument has circled around whether or not it was a necessary medical treatment, whether or not they were on the right protocol, whether or not they could have been on a different protocol. But there has been not one piece of evidence that has said it wasn't for medical treatment. And in fact, all the evidence is that ketamine is for the treatment for excited delirium. Even Dr. Robinson agreed to that. Dr. Mitchell conceded that he would defer to experts in that area, but that to the extent it was to help settle acidosis, he concurred. On the defense side, certainly the experts all said that this is medical treatment, and Dr. Hill was unequivocal that that is the only treatment available if you're in this protocol. So it is our position, and I would say at the court, to a couple cases, McKenzie 458 P. Second 232, Bramlett 573 P. Second 94, Calvarisi 534 P. Second 316. What we're talking about in those cases, it says a statute which prescribes different degrees of punishment for this, well, I'm shifting here, sorry, where the statute describes different degrees of punishment. Now I did it again, Judge. So let me shift to the second part of the argument. Those apply to the sentence enhancer. First, I stand on that there's no evidence as to this medication being used for anything other than a medical treatment. As to the sentence enhancer, where I was going, the remaining sentence enhancer takes this drugging victim charge, adds a sentence enhancer of serious bodily injury / death. In this case, the only allegation is administration of ketamine caused the death. That is what's at issue in the reckless manslaughter count. That is what's at issue in the criminally negligent homicide count. What the case law says is a statute which prescribes different degrees of punishment for the same acts committed under like circumstances by persons in like situations is violative as applied of the Equal Protection Clause. This is not an elements test. It's not a strict elements test. Rather, what we're looking at is there a distinction in principle as opposed to purely semantic? And in this case, what happens is criminally negligent homicide and reckless manslaughter are non-mandatory, probation-eligible charges. Second-degree assault, that is historically the one count of second-degree assault that has historically always been non-mandatory, is this drugging victim count. The only way that we've got a mandatory at play is by a sentence enhancer alleging caused the death, which is the very charge of reckless manslaughter and criminally negligent homicide. So to the defense, this is exactly semantics, and it's completely at the discretion of the prosecution. They have taken a charge, you gave a drug, you caused the death, they add a sentence enhancer, they get a mandatory prison sentence under second-degree assault. Those exact same allegations in principle are what would constitute reckless manslaughter and criminally negligent homicide, which are non-mandatory. So what they've done is elevate a second-degree assault to a more serious situation. And what the case law says is there must be substantial differences having a reasonable relationship to the people involved and the public purpose sought to be achieved. So in this case, if the public purpose is to prohibit a death, that is reckless manslaughter. That is criminally negligent homicide. to take second-degree assault that has always been non-mandatory, add a sentence enhancer causing serious bodily injury, death. And let's make clear, nobody has argued serious bodily injury. They've been arguing cause of death. So they are saying it's death. That you just made that second-degree assault the most serious charge in the case. And that violates, as applied, Mr. Cooper's equal protection and constitutional rights. So we would ask the court either to dismiss the charge completely because of the fact that there is no evidence that the ketamine was used for anything other than a medical treatment, albeit the people are arguing they were on the wrong protocol. The medication still was being used for a medical purpose. Or to dismiss the sentence enhancer charge as a violation of Mr. Cooper's constitutional rights.
Okay, on behalf of Mr. Cichuniec.
Thank you, Your Honor. I thought I would have some clarifying remarks. I would join the legal arguments of my colleague on behalf of Mr. Cichuniec. Stand on the record with respect to the reckless manslaughter and criminally negligent homicide and serious bodily injury second-degree assault charge. I would join the arguments with respect to the other second-degree assault charge that's at issue, except to add this factual detail. On top of there being no evidence that the ketamine was administered for anything other than a medical purpose, the only evidence that the prosecution appears to have offered is the opinion testimony of Dr. Mitchell that there was no medical reason to provide the ketamine. So they're simply trying to prove a negative. However, there has been no evidence that it was the intent of either of these defendants to administer ketamine for anything other than a medical purpose, which amounts to they may have misdiagnosed the illness for which they were applying the medicine, but that doesn't change their intent to apply the medicine for a medical purpose. And having said that, I rest on the record, Your Honor.
All right, thank you. For the people.
Judge, I'll start with this equal protection argument, which the court has already ruled on and it's already been briefed. The defense filed motions to dismiss these charges early on in the case under this equal protection argument, and the court previously denied it. So I don't think that the argument is proper here where we're just talking about evidentiary sufficiency. But to the extent that it has been re-raised with the court, reckless manslaughter and the second-degree assault unlawful administration contain different elements and they protect against different conduct, and therefore there is no equal protection problem. First, reckless manslaughter, of course, only requires the intent of recklessness, whereas the second-degree assault unlawful administration of drugs requires an intent. So because of the different elements, there per se can't be an equal protection problem there between those two things. Additionally, the argument that there has not been evidence of SBI and therefore they merge is incorrect. The people have argued SBI, both hypoxia, acidosis, and aspiration. But even outside of that, death itself is SBI. And so that has also been presented to the court there. They guard against very different behavior. Reckless manslaughter, obviously, the very general concept of consciously disregarding risk and thereby causing somebody's death, whereas second-degree assault is deliberately targeted at people who administer substances or drugs with the intent to cause stupor. So from that perspective, there's also no equal protection problem. If the court needs further articulation of these arguments more eloquently than I can do so, you can review the previous briefing on this issue that came up earlier in the case. But as a factual matter, there's abundant evidence to indicate that this was an illegitimate, unlawful administration of ketamine, not for a legitimate medical purpose. First, there's the direct testimony from Dr. Mitchell saying that there is no legitimate medical purpose for this. Doctors Buther and Robinson indicate that there was no medical necessity for this or no medical indication for this. Moreover, Dr. Hill's testimony that ketamine was only to be authorized within the protocols. Defendant Cichuniec admitted he exceeded the protocols. He estimated Mr. McClain's weight with a proper dose of 425 milligrams, but then rounded up to 500 because he said he was extra agitated, admitting that he was practicing an unauthorized administration of the ketamine. But more than that, Judge, there's a ton of evidence for the jury to infer that this was for an illegitimate purpose. The protocol specifically says that you're not to use ketamine for convenience or punishment. If it's used for either of those purposes, it would be an illegitimate use of the ketamine. And from the complete lack of effort in assessing Mr. McClain, the complete lack of care shown to him after the paramedics arrived on scene, and the fact that although the defendants purport to be disgusted by the excessive uses of force by their co-defendants from the police department, they did absolutely nothing to rein that force in or in any way discourage it. The jury absolutely could infer that this was for the purpose of either punishing Mr. McClain or just for their convenience, showing up at the scene, hearing, hey, this guy's causing problems, and thinking, boy, the fastest way to solve this problem is just to give him 500 milligrams of ketamine. I think that's particularly true given the implausibility of their explanations for why they gave such a significant overdose of ketamine to Mr. McClain, and the egregiously misleading statements that both defendants made in their interviews with Detective Ngui and here on the stand. I think all of that evidence together permits the jury to infer that this was given just for the convenience for the defendants or as punishment for resisting the officers rather than for any legitimate medical purpose. Because there's also there's an abundance of evidence that there was no legitimate medical purpose for administering ketamine in this scenario. Mr. McClain clearly didn't have excited delirium. He's speaking cogently, he's responsive to pain, and the defendants didn't undertake any reasonable efforts to try and figure that out. So I think that the people have met their burden for these charges to proceed to the jury. There's no equal protection problem with regards to the reckless manslaughter and unlawful administration counts, and I would ask the court to deny the defense motion.
All right. Once again, the court will hearken back to the Bennett standard of 514 Pacific 2nd, 466. As far as the court can determine, it's really the same standard as at the close of the People's case, but it could, of course, take into consideration other evidence that was presented during a defense case. Again, the court must give the prosecution the benefit of every reasonable inference that may fairly be drawn from the evidence, and that includes direct and circumstantial evidence. The credibility, and here I think I'm going to just join the two because the credibility and the weight of certain evidence or testimony really needs to be resolved by the jury. There have been wide variations, I suppose, concerning the cause of Mr. McClain's death. And those are things that the jury is going to have to figure out in determining culpability or lack thereof in this case. The court would find that there's more than a modicum of relevant evidence that would rationally support a conviction beyond a reasonable doubt, in particular with respect to the assault, reckless manslaughter, and criminally negligent homicide, if the jury assigns weight in a fashion they're allowed to do. And they could do so based upon more than guessing, speculation, or conjecture. The court has previously, the equal protection issue was raised, and the court issued a written order on that, and I'll adopt the written order. the focus of the argument for the defense has to do with the counts respectively under section 18.3.203.1E. That's popularly, at least in circles of criminal attorneys, called drugging. It's often a plea bargain case where folks pleaded that because of, as the statute is written, has some specific behaviors that the legislature chose to treat differently, and that would be intentionally caused stupor, consciousness or other physical or mental impairment to the victim by administering a drug, substance, or preparation capable of producing the intended harm. And here the intended harm that the legislature was seeking to criminalize would be causing stupor, unconsciousness, or other physical or mental impairment or injury. So the court would find that taking the evidence in the light most favorable to the people and the reasonable inferences therewith, that there is sufficient evidence that the jury could conclude, not based on guessing, speculation, or conjecture, but rather based upon the testimony and what weight and credibility they assign to it. So the court will deny the request to dismiss the second-degree assault drugging counts. As mentioned, the court has previously entered an order, and I adopted the rationale. And I think the focus of, well, actually, it was focused on both this afternoon and when the court issued its prior order. So what it is, I suppose, is the combination between a combination of, if you will, 18.3.203.1E and 18.3. I'll find the right one here. 18.1.3406.2A, Roman 1B, that does potentially raise the penalty or sentencing range, although it would be, again, within the range of the intent to cause bodily injury, causing serious bodily injury count. But the court will, based upon the time when it was raised, the court will look to Rule 12 of the Rules of Criminal Procedure, specifically B2, and the sentence reads, when a motion challenging the constitutionality upon which the charge is based is made after the commencement of the trial, the court shall reserve its ruling on that motion until the conclusion of the trial. So, if necessary, I may readdress it at the end of the case, but I think I've already addressed it sufficiently in the court's written order. So the motions for judgment of acquittal will be denied. Anything else we need to discuss? Yeah, I think we need to start looking at them as soon as possible. Do that first and then upload them after you get that done. For the people.
Shall we come back at 8 to talk about jury selection?
Can we do 8:15?
Boss, sir.
Well, I'm just, for those who practice in Jefferson County, they each have two judicial assistants who kind of switch off between early morning and getting off early versus staying late. That's not our protocol here, so it does take my staff 15 minutes or so after they arrived to at least get things opened up and set up for folks. So we'll try 8:15. I don't know who my court reporter is tomorrow. Do you? Okay, well, we'll reach out and see if, I'm fairly confident that they can do that. The only glitch might be if I start at 8:15 rather than 8:30 would be, I don't know the answer to this. But in a few pinches, I've had court reporters report virtually. So if we're okay with doing that, it might mess up the expedited transcripts a little bit. I don't know. I don't know all the procedures, but I think we can try to get 8:15 if is that okay with you guys? Yeah. All right. Yeah, when you say I'm the boss, sometimes that's not really always the case. All right, the court will be in recess.